Hey, I've got 9 o'clock. Let's go ahead and get started. I'm going to call to order the Nevada Tax Commission meeting scheduled for January 24th at 9 a.m. Tina, would you call the roll of the commissioners, please?
Yes. Commissioner Littman,
Present.
Commissioner Bursey,
I am here.
Commissioner Brown is absent today. Commissioner Johnson,
Present.
Commissioner Wren,
Present and accounted for.
Commissioner Byram,
I'm present.
Commissioner Witt,
Here.
and Chairman DeVolt.
And I am here as well. Before we call for public comment, I just want to caution everyone that personal attacks are not appropriate and will not be tolerated during this meeting. So please be respectful of everyone at all times, and I would certainly appreciate that. So thank you. So with that, Tina, is there any public comment? Anyone that would like to provide public comment? Please dial *9 and to be placed in the queue, and then Tina will let you in. If these are public comments relating to items on the agenda, please wait for that agenda item rather than making public comment with regards to anything on the agenda. So with that, is there any public comment at this time?
I do not see any public comment at this time.
Okay, very good. Thank you, Tina. Director Hughes, would you administer the oath to any parties that plan to testify today?
Yes, thank you, Chairman DeVold. To all parties today that are choosing to testify today, you are testifying that you are telling the whole truth.
Okay, very good. Thank you. Next item is the meeting minutes for December 6, 2021. Is there any additions or corrections to those minutes? If not, could I hear a motion to approve?
Commissioner Witt, move to approve the minutes.
Commissioner Wren, second.
I've got a motion by Commissioner Witt, seconded by Commissioner Wren. All those in favor, please signify by saying aye.
Aye.
Anyone opposed? Okay, minutes are approved. Next item is the consent calendar. Is there any items that anyone would like to pull from the consent agenda at this time?
This is Commissioner Witt. I don't want to pull an item. I just want to recuse myself from item C1, Reno Rock Transport.
Okay, thank you. And I believe we need to pull item E3, Spring Mountain Driving School, for some additional clarification. So Director Hughes, I'll ask you for that clarification when that time is appropriate.
Thank you.
Is there any other items that anyone would like to pull from the consent calendar? Okay, hearing none, is there a motion to approve the consent agenda items 3A, B, C, D, E, F, with the exceptions of item C1 and E3?
So moved.
Second.
Okay, I've got a motion by Commissioner Wren, seconded by Commissioner Byram. All those in favor, please signify by saying aye.
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 Is there anyone opposed? Very good. Could I also get a motion to approve consent calendar item C1, Reno Rock Transport LLC, with Commissioner Witt abstaining?
So moved.
Second.
Okay, I've got a motion by Commissioner Wren, seconded by Commissioner Lippman. All those in favor, please signify by saying aye.
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 Anyone opposed? Anyone abstaining?
Commissioner Witt abstains.
Thank you, sir. Okay. Director Hughes, could you go ahead and give us the clarification on the Spring Mountain Driving School, please?
Yes, thank you, Chairman DeVold. So E3 is Spring Mountain Driving School, and we have Natasha Gabriel from the Attorney General's office that will make that clarification on the record. Thank you.
Thank you, Director Hughes, and thank you, commissioners. I would like to direct your attention to page 3 of the settlement agreement, commissioners. We negotiated department and the taxpayer to a total agreed amount of $1,396,922.47. The way it was represented was that this included 3/4 of the tax deficiency and includes 1/2 of the interest. I would like to clarify that although that is the agreed amount, the representation calculations are a bit off. So that amount includes approximately 3/4 of the tax deficiency, but it actually does not include any of the interest. However, we did negotiate, the department and the taxpayer did negotiate this particular dollar amount. And in the spirit of negotiations and settlement, the department is still willing to honor that amount, although it doesn't represent any interest if the commission is so inclined to approve it. And I'm open for any questions if you have them.
Thank you, Ms. Gabriel. Are there any questions of any of the commissioners?
Ms. Gabriel, this is Commissioner Lippman.
Hi, Commissioner Lippman.
Was that just an error or? Yeah.
It was a clerical error, Commissioner Lippman. We overlooked that amount represented while it represented 3/4, it actually didn't represent any of the interest. And that was our mistake before we went into negotiations. And I think taxpayer might have overlooked it as well, honestly.
So the dollar amount is consistent with the negotiation throughout.
That is correct, Commissioner.
Okay, thank you.
You're welcome.
Are there any other questions? Is there a motion to approve?
Commissioner Lippman moves to approve item E3 from the consent calendar, Spring Mountain Driving School, consideration for approval of the settlement and stipulations. Do I want to say as modified by with this clerical error, or just as Ms. Boardlove? Any advice here?
Myself there. To the extent that you want any changes, I guess, to the amounts, you would need to get agreement from the taxpayer. I don't know if they're on the line today, but to make any changes to what they've previously agreed to, I mean, you could always do a conditional approval and approve it subject to the taxpayer's later agreement. But approval of certain terms. If the taxpayer doesn't agree, then you're kind of back to the drawing board, and something else would have to come before you on a future meeting.
Well, this is very taxpayer favorable. And so the dollar amount is remaining the same. It's just we're striking the "and interest" language, correct? Yep, Ms. Gabriel.
Yes, that is correct. So the dollar amount stays exactly the same.
Again, it's such a minor change that I don't think you'd have any issues from the taxpayer front. So I would say make it a conditional approval, conditioned on the taxpayer agreeing to the change, but and you can approve it with the change. Unless, Ms. Gabriel, you think that the taxpayer may be less likely to agree to that. I'm guessing there won't be any objection on their part because it's not changing the substance.
I would agree with you, Chief Bordelove. The taxpayer is more concerned about the dollar amount.
Chairman
I
DeVold,
would say.
this is Tina. We do have the taxpayer representative here.
I was just about to ask that. Thank you. Could the representative for Spring Mountain Driving School please identify themselves and spell your name for us, please?
Yes. Good morning, Commissioner DeVold. Chase Whittemore for the record, Argentum Law, representing Spring Mountain. That's WHITTE, M as in Mary, ORE. And yes, thank you very much to the Deputy Attorney General, Gabriel. It was a pleasure working with her and the department. And we certainly would agree to just strike that language that says, and 1/2 of the interest owed.
That does not surprise me, sir. And so I will ask for the E3 item for the consent. I will move to approve item E3 of the consent calendar, Spring Mountain Driving School, as modified with the and 50% of the interest language in the description of the dollar amount struck.
Commissioner Bursey seconds.
I've got a motion by Commissioner Littman, seconded by Commissioner Bursey. Any other discussion? All those in favor, please signify by saying aye.
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 Anyone opposed? Okay, motion passes. Thank you, Mr. Whittemore, for attending today, and Ms. Gabriel, thanks for your help.
Thank you very much.
Okay, that's the last items on the consent calendar. So anyone that's on the telephone with a item that was in agenda item 3, you are free to leave. Your items have been approved. So with that, I'll move on to the compliance division, item 4, Executive Director Hughes.
Yes, thank you. Item 4A, approval of refund credit requests in excess of $250,000. The first item is Zurich American Insurance Company for possible action. It's Brandon Mackey representing the department.
Brandon Mackey, if you're on the telephone, I see you raising your hand now. Thank you.
Good morning, everybody. We have some issues getting our phone to unmute. So good morning, Chairman and Commissioners. For the record, my name is Brandon Mackey, M-A-C-K-I-E, Tax Program Supervisor for the Nevada Department of Taxation. Just to clarify on this memo that was sent to you guys, let the record reflect that there was an error on one of the dates shown. It was printed as June 30th, 2021. That should have shown June 30th, 2020. The change of that does not change the outcome or the amount of this refund request. With that said, today the Department of Taxation is recommending the approval of a credit refund in the amount of $597,234 for the overpayment of industrial insurance premium tax for Zurich American Insurance Company for the tax year of 2020. After processing the taxpayer's reconciliation return for the 2020 tax year, the department reviewed and verified the taxpayer filed and paid their quarterly returns timely. However, they did not apply their Division of Industrial Relations credits to the quarters ending March 31st, 2020, June 30th, 2020, September 30th, 2020, or December 31st, 2020. This was discovered by the taxpayer when they filed their annual reconciliation return, resulting in an overpayment and a refund request in the amount of $597,234. I am available for any questions that the department or the commissioners may have.
Thank you, Mr. Mackey. Any questions of the department? Is there a motion to approve?
Commissioner Witt, move to approve.
Commissioner Johnson, second.
I've got a motion by Commissioner Witt, seconded by Commissioner Johnson to approve item 4A1. All those in favor, please signify by saying aye.
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 Anyone opposed? Okay, very good. Director Hughes, next item.
Mr. Chairman, this is Commissioner Rand. Can I have a clarification, please?
Yes, yes, sir.
What happened? Did we pull item F?
That was part of the consent calendar. It was
Okay.
Part of 3, the consent calendar.
Okay, I guess I was confused then because it came up as a separate line item as an offering compromise, not into the consent agenda.
I don't know. My agenda shows it under the consent calendar. Director Hughes, was that the intent?
Yes, Tina can also verify, but I believe it was the intent to be under the consent agenda. It's under my agenda as a consent item.
Commissioner Wren, did you have some items that you would like to discuss on that?
Yes, sir, I do.
Okay.
And I apologize. I don't see it under the consent agenda. It comes up as a separate line item. So I do, yes.
Okay. Is there anyone opposed to going back and removing that item from the consent calendar approval and allowing Commissioner Wren to ask some questions? Is there any commissioner that is opposed to that? Okay, very good. Commissioner Wren, go ahead.
Thank you, Mr. Chairman. I apologize. Like I said, it showed up as a line item. I didn't realize it was under the consent agenda. This is one of those that I do have a lot of problem with. In this situation, this taxpayer is asking to pay $16,750 when they owe $104,612.50, of which that total amount is $43,693.73. I understand people getting in hardships. What I have a problem with is when a taxpayer asks to pay $16,000, but in 2021 goes out and buys 2 cars for a total amount of $53,754 with monthly payments of $1,543.49. That doesn't make sense to me. So my basic question is, why are we making an offering compromise when it's quite apparent that the taxpayer isn't really trying to live up to their obligation?
I believe Lizette Arceo is the staff member. Is Lizette available by chance?
Good morning, Chairman. This is Lizette Arceo for the department.
Good morning.
Morning. To answer Commissioner Wren's question, the department did consider obviously the large monthly payments for the vehicles, and we did question. The reason the department is recommending approval of this offer is that the entire amount is not personally liened. Therefore, the department can only pursue Mr. Torresian for the audit period, which is a base tax of $16,711.60. With penalties and interest, the total amount for that audit period is $38,150.55. That's why the department was moving forward with the recommendation, as a large portion of the debt is not personal lien. The department has no recourse to pursue the taxpayer for that balance.
So are you pursuing Blue Diamond or Blue Diamond's representatives for the additional monies?
Blue Diamond,
Apparently that is his wife's company. I mean, all of that documentation is in the
I apologize. I apologize. No, the department did pursue his wife for responsible person. However, the administrative law judge found that she was not responsible for this debt. So no, we cannot pursue the wife or the wife's business for this debt.
Okay, and so just so I understand, why is he only responsible for $16,000?
When the department pursued responsible person, the additional periods, which are the periods prior to 2011, so there was a lot of periods where he filed no money returns. The department had not pursued any type of responsible person, nor had the taxpayer signed a payment plan at that time. So once we got to the point where we were pursuing responsible person, those periods were already out of statute to pursue responsible person. So we could not include them in the request when we did a responsible person against Mr. Torreson and his wife.
Okay, thank you. Thank you, Mr. Chairman. Again, I apologize for my confusion. I will not challenge the prior approval.
I have an additional question for Ms. Lizette Arceo.
Yes, Commissioner Littman, go ahead, please.
Ms. Arceo, thank you so much. Your memory and attention to detail is amazing and quite impressive with the vast number of files you have. I was not able to determine the age of the taxpayer in the file. I apologize if I missed that detail, but it does help us, at least it helps me, frame the analysis. So I'm just wondering if you recall that, because quite often we have senior citizens who are collecting Social Security and not in a health position to work anymore. I didn't think that was the case here, but I welcome your input.
Thank you, Commissioner Littman. Correct, we didn't add his age, which is unusual. We normally do. And he is, according to our records, he is in his either late 40s or early 50s. So we do normally add that information in the memos just for the commission, as the commission has in the past requested that information. In this one, it seems like we missed it.
Thank you.
We just missed it.
Thank you for that.
Okay, since this item has already been approved, Commissioner Wren, do you have any objection to letting that approval stand?
No, sir. Thank you very much.
Okay, very good. Director Hughes, the next item on the Compliance Division agenda.
Commissioner, this is Attorney Ben Lahavi on behalf of Zion Gardens for consent calendar 3E1. I just want to make sure that we're done and that we can log off from this meeting.
You may. That item has been approved. Thank you.
Thank you.
You're welcome. And that's a good reminder. So anybody that was on the consent calendar, any item under item 3, your item has been approved. Director Hughes, next item.
Yes, the next item is 4B, petition for reconsideration of department's denial of exemption status for organization created for religious, charitable, or educational purposes pursuant to NRS 372.3261. The first item is Equinox, Reiki, and Tarot. We have Andrea Nichols from the Attorney General's office representing the department.
Good morning, Chairman and Commissioners. Senior Deputy Attorney General Andrea Nichols, NICHOLS, appearing on behalf of the Nevada Department of Taxation. This is taxpayers' appeal of the department's denial of its request for exemption from sales tax as a charitable organization. Just as a preliminary matter for the record, there is a typo at the bottom of page 3 of my brief. I think it would be page 5 of 52 in the packet that was submitted to the Tax Commission. So on page 3 of my brief, lines 27 and 28 are repeated on lines 1 and 2 of the next page. And I asked the Tax Commission to accept my apologies for any confusion. I believe the taxpayer is on the line.
I believe Ms. Marin is on the line. Good morning, Ms. Marin. Thank you for joining us today. This is your appeal. Go ahead and make your case, please. And could you state and spell your name for the record, please?
Yes, of course. Thank you. It is Laurie Marin, Laurie. Last name is Maren. Yeah, so this has been, I guess it's been a year going now, because I first applied in December 20 or January 21 when I got my IRS approval for 501c3. And I was denied and didn't understand why. And the department told me, well, actually the department didn't reply that time. So I reapplied, hoping that I might get more information that way, since I wasn't getting anything by calling or anything. And then I was denied, and I was able to talk to somebody at the department, and they told me to appeal it. And that was the only way to find out more information about why it was denied. So I apologize for sending it in twice and like having this go through a year-long process, but I'm just trying to figure out how this all works. That's why I sent in the appeal. But at this point, my question, my issue, my need to understand what I should do at this point is that the reason that it was denied, which I agree with all the reasonings that were given in the brief, my business is not able to operate as planned because of COVID. I should be able to get into hospitals to provide Reiki to patients, but I can't do that with the restrictions and such is the world today. When I started this, I had a lot of hope that things would change faster than they have. But so I guess why I'm still on the call and trying to have this discussion is, what are you doing? Do you have any policies for COVID affected businesses in this regard?
Thank you, Ms. Marin. I'll let Deputy Attorney General Nichols answer that for you. So,
Thank you, Chairman. I've spoken, via email to Ms. Marin several times. I tried my very best to answer her questions. I did try, she wanted to proceed to I think she understood that the reason for the denial is that she was not able to show that the primary purpose of her company is charitable. And I think she understands that. She asked to proceed to the tax commission so that she could ask questions. And I told her that this really was not the appropriate forum, that she could ask questions of me. She can certainly ask questions of the department. And once, if she's able to show that the primary business of her, or the primary purpose of her business becomes charitable, she can always reapply, and it is also free to reapply. So if there's any specific questions, I'd be happy to answer them.
Ms. Marin, would you be okay if Senior Deputy Attorney General Nichols calls you directly with those items, and you two can work it out? It sounds like, possibly there is a avenue to grant your request, but it would need to be under modified terms and circumstances that Andrea Nichols would be the best person to help you with that. She's got a lot of expertise in that area. Would that be appropriate?
Well, I appreciate you saying all that. The message that I received from her is that I can't advise you, and wondered if we could just take this off the agenda item. And so you're the first person right now that I've heard this message of getting approved under some different circumstances, and I would love to talk about that. That's what I've been trying to do this whole time. So
if I may clarify, I can't provide Ms. Marin with legal advice because I am the legal representative for the Department of Taxation. And so I can't give Ms. Marin legal advice, but I am happy to assist her with the procedure. And I've always assisted people with connecting with the correct person at the department for their issue.
I think maybe that's the best solution here is, Director Hughes, is there someone that can contact Ms. Marin to discuss her business and her potential ability to get the charitable exemption that she's asking for. I mean, if it doesn't apply, I mean, the standards are pretty plain language, I think. So if we could help her with that, could we ask you to commit to that for me, please?
Yes, Chairman DeVold, we will have Charlene Bernardo reach out to Ms. Marin. Thank you.
Okay, very good. With that, is there a motion with respect to Equinox at all?
Mr. Chairman, Commissioner Byram,
Yes.
I would move to uphold the department's denial of religious, charitable, or educational exemption for Equinox, Reiki, and Terrell.
Commissioner Witt, second.
Any other discussion? All those in favor, please signify by saying aye.
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 Anyone opposed? Ms. Marin, thanks for your time, and someone from the Department of Taxation will be in contact.
Okay,
Thank
thank
you.
you so much.
All right. See, Director Hughes, I believe the next matter has been continued to a future meeting. Is that correct?
That is correct. Item 4B2 has been continued.
Okay, very good. Next item on the agenda then.
4B3, Nevada Health and Bioscience Asset Corporation. And again, we have Andrea Nichols representing the department.
Good morning. For the record, Senior Deputy Attorney General Andrea Nichols appearing on behalf of the Nevada Department of Taxation. This is an appeal of the denial of a request for exemption from sales and use tax. The department requests that the commission uphold the denial because the exemption cannot be used for the purchase of construction materials, and that's very clear from the statutes.
Thank you. And I see Mr. Dixon is a representative for the taxpayer. Could you state your name and spell it for the record, please?
Yes, absolutely. Brian Dixon, B-R-Y-A-N, Dixon, D-I-X-O-N, on behalf of Nevada Health and Bioscience Asset Corporation.
Okay, and this is your appeal of the denial. Go ahead and make your case for us, please.
Certainly. I think part of the issue is the lack of communication during COVID has certainly been an impediment to flushing out the issues. When this application was first issued, candidly, the wrong box was checked, labeling it as an educational institution. This is the organization that has led the fundraising, planning, construction of, and now is furnishing and providing all the internal materials for the UNLV Medical School. And the plan is this is the entity that's going to lease the building to UNLV for $1 a year, and then eventually gift it to UNLV. And it seems like that currently the issue is, well, we're kind of leapfrogging, putting the cart before the horse as to whether this is a charitable organization versus the types of transactions that will qualify. Let's not overlook the fact that there's a lot of other property, libraries, desks, computer information, items, medical equipment for the clinic that still has to be purchased. And of course, the taxpayer is saying, look, we're looking at this one issue. However, it still qualifies as a charitable organization.
Thank you, Mr. Dixon. Ms. Nichols, do you have a response?
Thank you very much, Chairman. First off, and I believe Mr. Dixon actually provided the legislative history for the statute that shows the legislature providing funding for the furnishings for the building. I believe I pointed out in my brief that the organization was formed for funding and construction of the medical building at UNLV. We have NRS 372-340, which specifically provides that the taxes imposed under this chapter apply to the sale of personal property to and the storage, use, or other consumption in this state of tangible personal property by a contractor for a governmental, religious, or charitable entity, which is otherwise exempted from the tax unless the contractor is a constituent part of that entity. UNLV is exempt from taxes on their purchases. But this statute was passed specifically because the religious and charitable exemption doesn't apply to the purchase of construction materials. And it's very clear in the materials that they submitted that they were formed to construct this building. And then I also would point the commission to NRS 338.1423, which prohibits a public body from entering into a contract for public work that provides for construction materials to be purchased by the public body or a contractor acting on behalf of the public body, which Nevada Health Bioscience Asset Corporation, I think, would have to be considered a contractor acting on behalf of UNLV. Now, I put in the legislative history for NRS 338.1423 because I think it is specifically on point. When introducing this legislation, Assemblywoman Kirkpatrick, and I'm just going to paraphrase, but the exact legislative history for the introduction of the bill that enacted this statute is in your packet. But basically, I believe it was about 2015, sales tax revenues were going down, and the state budget was hurting. Assemblywoman Kirkpatrick testified that she had discussions with the governor, and they couldn't understand why there was no sales tax revenue when there was all this construction going on. Well, they looked into it a little further and they found, and I think the example that they used was one of the counties, but they also testified that they were having problems with NSHE. I can tell you from personal experience, it was a big problem with UNR. But the example they used was a county that wanted to build a building. And what the county did is purchased all the materials without paying sales tax and then transferred the materials to the contractor. And there's also testimony right in there that the intent of the law is to allow a city or university to buy restroom supplies, but in building the restroom, they need to pay construction costs, including sales tax. So if Nevada Health Bioscience Corporation is constructing a building, they need to pay sales tax on the construction materials, even if they are a charitable organization or they're buying the construction materials for an educational organization. And that's just very clear in the statutes and in the legislative history behind the statutes. And I'd be happy to answer any questions.
Thank you, Ms. Nichols. Mr. Dixon, do you have any rebuttal before
Yes, I do. Yes, I do.
Questions?
I believe there's 2 points that should probably be brought up as a rebuttal. First, I feel like the issue regarding construction isn't ripe for consideration because we are getting into what transactions may be exempted from a general exemption. It's as if we are looking at UNLV and saying, what is unrelated business income tax to UNLV? Irrespective of that should be addressed in a separate way. The question is whether Nevada Health and Bioscience qualifies as a charitable organization. We're overlooking the fact that it will be buying medical equipment, expensive medical equipment to furnish to the building, irrespective of the construction costs. I think the second issue is to point out that under NRS 372, 340, whether it was an oversight or not, but it doesn't refer to educational institutions. And candidly, I think the Attorney General has brought up a very good point. Perhaps the construction equipment could be exempt. That was not originally considered by the taxpayer, but it looks like it very well may be. But irrespective of that, the question is whether it qualifies as a charitable organization.
Thank you, Mr. Dixon. Any final thoughts, Ms. Nichols?
I would point out in their application materials, it's very clear that in their contract with UNLV, that the whole purpose of the contract is for construction of a medical building. In their materials, they put in the timeline for all of the construction, and that's attached. Let's see, it's exhibit, I believe, I'm sorry, I can't tell you. It's just part of their, the materials that they submitted with their application. So it's part of Exhibit A. It's a big timeline of construction. It's just so obvious that this is construction. And then even attached to Mr. Dixon's brief, Exhibit 9, he put in some newspaper articles. Development Corporation, with a headline for Exhibit 9, Development Corporation to build UNLV's long-awaited medical school. So I think it's clearly demonstrated that the whole purpose of this exemption is for construction. And as I said, that's one thing that the exemption cannot be used for.
Thank you, Ms. Nichols. I'm going to bring it back to the commissioners now. Are there any questions of the taxpayer or the department at this time?
Commissioner Lippman, while I find these arguments incredibly interesting and intellectually challenging, I do want to unfortunately recuse myself because I am a UNLV employee, but I do appreciate the back and forth. So thank you.
Thank you.
Mr. Chairman, this is Commissioner Byram. I do have a question. I understand the construction materials themselves, the argument about those being taxable and the history for that, but the individual personal property that's being also purchased and donated, is that to be dealt with separately? I mean, are they exempt for purposes of the personal property type purchases and donations and not the construction, the tax on the construction materials? Is there a way to split it that way?
Commissioner, I believe in the last legislative session, the legislature allocated, I'll get the number wrong, but several millions of dollars for
about 25.
furnishings. If UNLV was to buy those furnishings, UNLV could buy those furnishings without paying the sales tax. The problem here, for purposes of an exemption, you have to look at the primary purpose of the organization. And here the primary purpose of the organization is construction. But I would assume, because they have such a close relationship, somebody from it looks like Nevada Health and Bioscience Asset Corporation is building this to UNLV specifications. And I don't see any reason why UNLV couldn't buy the furnishings using the money that was allocated by the legislature for that specific purpose.
Thank you, Ms. Nichols. I think you answered the question that I had. You know, what really stops UNLV for purchasing those expensive medical pieces of equipment and having Nevada Health donate the exact amount back to UNLV? Is that even an option, Mr. Dixon?
Not according to the legislature and Governor Sisolak. They have said that is going to Nevada Health and Bioscience. So I suppose there could be some renegotiation to send it back to UNLV, but that's not what was allocated under the general budget.
That's funny because when I looked at the budget statute, I saw that that money was allocated to UNLV and
Okay.
not to Nevada Health Bioscience Asset Corporation. And I can find that statute if it would be helpful.
Okay.
I think that would be super helpful. You know, I think what Nevada Health is doing is solving a major problem in the medical field. We need doctors and physicians and every kind of medical professional. And I want to try and figure out a way to help. They're obviously doing something that they're at $1 a year. It doesn't sound like that group is actually benefiting. I understand the construction component that it does not qualify, but I'd love to figure out a way that helps them on the equipment and textbooks and things of that nature that would qualify. So,
you know what I'm looking at, and it's a matter of public record from the last legislative session, Assembly Bill 492, Committee on Ways and Means. And I believe that is where the money was allocated to UNLV for the purchase of basically furnishings for the medical building.
That would be awesome if that actually is correct. Would you agree, Mr. Dixon? That solves a huge problem.
It does solve a significant problem, yes.
Okay.
I was under the impression it was in the taxpayer's account, so I would have to verify that. So,
please, please do. Is there any other questions from any of the other commissioners or comments? If not, I'll entertain a motion.
This is Commissioner Witt. I would move to support the denial for the Nevada Health and Bioscience Asset Corporation.
Commissioner Wren, second.
I've got a motion and second to uphold the denial. Is there any other discussion from the commissioners? Hearing none, all those in favor, please signify by saying aye.
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 Anyone opposed? Okay, the objection is upheld. Mr. Dixon, I applaud your efforts. Please continue to do your good work at UNLV. It's very needed, and we appreciate your time today.
Mm-hmm. Thank you.
Commissioner, Chairman DeVold, just for the record, I abstained.
Thank you. I apologize. Thank you very much for reminding me. Yes, with that abstention from Commissioner Littman, it is a unanimous vote without her. Next item on the agenda is, I'm sorry, go ahead, Executive Director Hughes.
Yes, the next item on the agenda is item 4C, consideration of adoption of hearing officer's proposed decision on remand from First Judicial District Court and taxpayers' objection to that proposed decision. The item under that agenda item is Airlift Helicopters, Inc. and ALP, Inc. We have Andrea Nichols representing the department.
And I see Mr. Bartlett is on the line as well. Good morning, Mr. Bartlett. Could you state and spell your name for the record, please?
Yes, my name is John Bartlett. That's B-A-R-T-L-E-T-T. I am the attorney for the taxpayer in this matter.
Okay, thank you. And Ms. Nichols, or is Ms. Nichols still on?
Yes, I am. Thank you, Chairman. For the
you.
record, Senior Deputy Attorney General Andrea Nichols appearing on behalf of the Nevada Department of Taxation. So just a little bit of background. This, I believe, came originally before the Tax Commission. A decision from the administrative law judge was issued in 2018, pretty much upholding the department's audit. The Tax Commission approved the ALJ's decision. The matter was appealed to the First Judicial District Court. The First Judicial District Court remanded it back to the Nevada Tax Commission, who remanded it back to the administrative law judge to consider a very, very small amount of evidence. In particular, Airlift Helicopter was given the opportunity to provide flight logs. The ALJ held another evidentiary hearing and has issued another proposed order, and the department is just requesting that the tax commission uphold the administrative law judge's proposed order.
Thank you, Ms. Nichols. Mr. Bartlett, do you have a response, please?
Yes, I did file an objection to the administrative law judge's latest ruling, which I'm sure you all have. And yes, this is a long and winding road case. I specialize in those. What we have before you today is basically the taxpayer is asserting that the assessments of use tax against what amounts to 3 helicopters is incorrect and should be reversed. This is consistent with the arguments made previously in matters before the remand. And I can summarize the issues fairly quickly for you. My client is in the business of providing helicopter services, and he acquired either by lease or purchase helicopters over the years to do those sorts of things. One of his contracts, which is still ongoing, I might add, that he entered into in 2007, and this is well before the audit period, which ran, by the way, from July 1st, 2012 to June 30th, 2015. Anyway, my client obtained a contract from the Arizona Public Service Corporation, which is the public utility in Arizona for electric utility. And he was hired to provide helicopter services for people at the Arizona Public Service Company to check their power lines throughout the state. And they required a helicopter to fly their people up and down the state to do that. The contract required my client to provide a helicopter in what amounts to 365 days a year. The helicopter had to be available for use at least 350 of those 365 days, and the rest was set aside for maintenance and things like that. And that contract again was signed in May of 2008 and continued, well, actually it's 2007, I'm sorry, and continues to this day. My client, to fulfill that contract, leased a helicopter from a company called GM Leasing out of Louisiana. And that is the helicopter referred to by its letters N2018R that you will see referenced in the materials a lot. Now, at that time, of the contract in 2007, GM Leasing delivered that helicopter to my client in Reno, Nevada. And they had a 1-year lease at that point. And the helicopter was delivered in Reno. It had some avionics put into it and an air conditioning unit, and off it went to Arizona and was used exclusively in Arizona at that point. At the end, a little bit past the first year of that initial lease with GM Leasing, the lease was terminated and a new lease was executed. That new lease was for the same helicopter And it changed a little bit of the lease terms, and that lease commenced September 1st, 2008. The initial lease in 2007 specified the delivery of the helicopter took place in Reno, Nevada. The new lease, the 2008 lease, specified that the delivery took place as is where it is. And at that point in time, the helicopter had been used for over a year in Arizona servicing this contract. So even though the lease did not specify a specific place of delivery, the 2008 lease, the helicopter was in Arizona. So why emphasize these points? Well, the law in Nevada on which state, or actually this is, the law in Nevada on which state gets to tax a lease of transportation equipment, which this helicopter was, because it was licensed to carry passengers. It was dictated by NRS 360.360 or 360B.360, sorry, as the place of delivery. And the place of delivery, my client asserts, was for the 2008 lease was in Arizona, because that's where the helicopter was and that's where it was being used 365 days a year. So my client has maintained throughout that Nevada should not be assessing use tax on the lease payments that he made for that helicopter. There was some discussion the first time we went through all of this as to whether or not Arizona was collecting tax on this helicopter. It turns out there is an exemption in Arizona for the lease of a helicopter used for this purpose. So Arizona was not collecting any tax on this helicopter because there's an exemption for it. The on remand, the Department of Taxation had been arguing, and one of the reasons they ruled against my client initially was because by the time of the audit, they are asking for helicopter flight logs for this helicopter. And they asserted that this was the best evidence of where the helicopter was at any one point in time. And my client was not able to produce those flight logs. And the reason he wasn't able to produce these flight logs, as he testified, was that this particular helicopter ended up crashing and was seriously damaged on August 30th, 2013 in Arizona. And under the lease, terms of the lease, and this is the 2008 lease again, under the terms of that lease, when the helicopter is returned to the lessor, as it was after it crashed, the lessor claims all of the flight logs and all of the maintenance logs, and they have to be returned with the helicopter. And that indeed is what happened. All the flight logs went back to GM Leasing, and my client no longer had possession of those 2.5 years later or so when the audit started. What we did have was other evidence, of course, that the helicopter was being used 365 days a year in Arizona, which was presented to the administrative law judge, and she didn't find that sufficient. When we get to district court, the district court remanded and said, well, if you can't get the flight logs, this is your opportunity to submit them. And my client was unable to obtain the flight logs. What my client did submit was purchase receipts for all the fuel that he was purchasing on a several times a week basis in Arizona, which provided a clear snapshot of where that helicopter was on any particular day that it was purchasing fuel in Arizona. And again, when that helicopter was being used regularly, it would sometimes refuel several times a day. So those were presented, which the administrative law judge said, well, those aren't flight logs, so we're not going to consider those. The other problem with the fuel receipts, however, is we only had them for the audit period. We didn't have them for September 1st, 2008, which again is the operative date to determine where this helicopter was delivered by the leasing company to my client, because that's what determines in the case of transportation equipment, which jurisdiction can tax it. So my client, again, is relying on the information that was already in the record that had been supplied at the first administrative hearing for that particular helicopter. The second issue with regard to this particular helicopter is, as I mentioned, that helicopter crashed on August 30th, 2013 in Arizona. And there's no dispute about that. There's documentation in the record about the helicopter crashing. And the department the department's counsel anyway, looked at the helicopter lease, the 2008 helicopter lease, and said, oh, well, this lease says, in his opinion, that my client had to continue to pay rent on the crashed helicopter until the lease terminates. And counsel thought the lease didn't terminate until the end of, until December of 2014. And so the auditor continued to assess $9,000 a month in use tax on this same helicopter N2018R, between September of 2013 and December of 2014. How could this be? That helicopter was crashed and returned. How can you keep taxing it? The department's basis was, well, the lease says the landlord, the lease says that the lessor can continue to tax it. Well, how can that be when the lease provisions provide that the rights of the lessor to collect rent is only until the lessee satisfies the landlord's requirements for termination of the lease. Well, what were the requirements? Well, as my client testified, and as is documented in the record that was prepared by the auditor, my client was required to pay the deductible for the helicopter insurance and forfeit his $9,000 deposit, which he did within 3 months after that helicopter crashed. So there was no more lease payments being made on N2018R after it crashed. My client satisfied what the lessor required. That lease was terminated. What did happen, which is also documented in the record, is my client had to replace the crashed helicopter. He still had this contract to fulfill. So he leased another helicopter from GM Leasing, the lessor, and that was helicopter N3180R. And there's a separate lease agreement dated in September of 2013 for that helicopter. The lease payments on that helicopter are $9,000 a month. The delivery terms for that helicopter stated in the lease were as is where is. Well, the helicopter was required for the Arizona Public Service contract. So that helicopter was not delivered in Reno, it was delivered in Arizona. So again, under NRS 360B 360, Nevada cannot tax that helicopter. And in fact, they did not tax that helicopter. In the audit, there were no assessments of use tax made on the lease of that helicopter by the auditor. Instead, the auditor left in the $9,000 a month lease payments on N2018R after that lease had terminated. So my client is asking for that to be reversed and those assessments of $9,000 a month made after August of 2013 to be removed. The next issue is when my client decided in November of 2014 that he didn't that he thought it might be better to buy a helicopter for the Arizona Public Service contract than lease one. And so he did. He went out and bought another Bell, same model, Bell helicopter. This is helicopter N62HP. N62HP was purchased and delivered in Oregon, Klamath Falls, Oregon, to my client. My client flew it to Reno, Nevada, had some avionics put into it. It was here about 12 days, and then it was flown to Colorado to have air conditioning put in, which is all documented. And from there, it was flown to Arizona, where it's been ever since and still being used there. The issue with regard to N62HP is, does my client owe use tax on the purchase price of that helicopter? So we're not dealing with a lease issue here. The law on that is, was this helicopter purchased for storage use or other consumption in Nevada? If it was, Nevada can tax it. If it wasn't, Nevada can't tax it. That helicopter was only in Nevada for a couple of weeks and has never been used in Nevada since then. Every once in a while, I believe it flies to a Nevada airport to be recertified by the FAA to carry passengers, which is the one quick trip. And back to Arizona it goes to keep doing what it's been doing. So my client argues that based on those facts, the use tax assessment should be reversed. At the district court, the judge said, well, we're going to remand and let you submit the flight logs for that helicopter. Fine, it came back and my client submitted the flight logs for that helicopter. And it basically demonstrates that helicopter was used nearly exclusively in the state of Arizona since its purchase, with the exception of being flown to Reno right after it was purchased to have avionics put in, went to Colorado to get air conditioning put in, and then it went to Arizona. It's all documented in the record. The department's counsel attacked the flight logs as being inadequate because they seemed to him to be inaccurate in certain respects. So they were nitpicking out dates and landings and whatnot. The way this helicopter was utilized, it was Arizona Public Service would notify the pilot that we need the helicopter to fly, to do this run today. We're going to go down a power line in rural Arizona. We're going to check power lines. And if we see something that looks off, we're going to land and inspect, the tower or whatever. The department thought that every time that helicopter lands, it needs to be logged into the flight log that it landed in such a place. And that's not true. Each landing is accounted for, but there's not a separate line item for each landing that is made out in rural Arizona where you're inspecting a power line. What is logged are matters relevant to the operation of the helicopter's engine, et cetera, which is, okay, we had a landing here and then the engine was turned off and then the engine was turned back on and it flew off successfully, and then we landed somewhere else, et cetera, et cetera. The department thought that it was suspicious that not every landing had a separate line item where it went from here to there and landed and went from here to there and landed. So what there was instead in the flight logs, oftentimes if the helicopter is flying in the general vicinity of Phoenix, would be it took off from Phoenix at the beginning of the day and it landed at Phoenix at the end of the day. And that would be the line item for that particular day for that helicopter. But it would also list for that day 5 landings, 7 landings, whatever. Department argued, therefore, that the flight logs were inaccurate. The flight log showed the helicopter being used nearly exclusively in Arizona. Landing in Arizona, landing back in Arizona. May have been the same place, may have been a different place. But What I feel that the department is arguing is that the flight logs are supposed to be generated for tax purposes, not for the purpose for which they really exist, which is for helicopter safety purposes and for logging how long the engine's being used and how long the batteries are being used and all that kind of stuff. Flight logs are not intended to be a tax document. They're simply a convenient way to show where a helicopter has been. And so I think it was improper for the administrative law judge to reject those flight logs and in turn argue that the taxpayer didn't prove by a preponderance of the evidence that helicopter was used almost exclusively in Arizona. The final issue is helicopter N173AL, which was a Hughes 369D helicopter. This was not the sort of helicopter that my client normally used. And in this particular case, he purchased the airframe quite a number of years before the audit period. In other words, he bought a piece. It was the airframe without an engine in it. And then over the time, he bought the parts to reconstruct the helicopter because this helicopter too had originally been a crash helicopter that they fixed the airframe. So over time, he bought the parts and he built an operating helicopter out of it. The helicopter became airworthy in January 2015. It was certified to fly. The issue with this helicopter is that the department believes it is entitled to assess $10,000 a month for the purported lease of this helicopter when no such lease existed and no such money changed hands. And in fact, this helicopter was never used by my client to produce any revenue at all. He never leased it out. He never used it for helicopter services. He just didn't use it. And then he eventually sold it after the audit period. So we have essentially $60,000 of taxable measure tacked on for this helicopter that we believe should be removed as inappropriate. So what was the department hanging their hat on? At that particular time, my client had formed a subsidiary, a separate corporation, it was Alaska Corporation, specifically to hold title to his helicopters. He thought that would provide some extra layer of liability protection. What it did cause instead is confusion. And he did this little pro forma 1-paragraph lease agreement between the Alaska company and his company, Airlift Helicopters, that purportedly leased the helicopter for $1,500 payable 6 years in the future for the lease of this helicopter. And it is that document that the department is using to claim that they can assess $10,000 a month. I submit that is a very thin reed on which to hang that argument because it ignores the actual facts of the situation. So those are the issues that continue to exist between the taxpayer and the department. And on all those issues, the administrative law judge ruled against us. We think the administrative law judge was incorrect on all of those issues. And so we're asking you to consider our arguments and in this appeal.
Very good. Thank you, Mr. Bartlett. Ms. Nichols, do you have a response?
Thank you very much, Chairman. Mr. Bartlett had the opportunity to present those arguments to the administrative law judge 3 years ago. On August 20th of 2019, the Tax Commission issued a decision upholding the administrative law judge's decision with respect to those very arguments. This matter is before the commission now on remand from the district court. And as Mr. Warbicki pointed out in his previous brief, the commission has no discretion to interpret the district court order to allow additional documents, which the ALJ actually did allow, because the remand from the district court charged the commission with carrying out the district court's specific instructions. And Mr. Warbicki, in his pre-hearing brief, when he was objecting to Mr. Bartlett's admission or request to admit additional documents, he objected to the admission of additional documents. The ALJ let him in anyway. But I would first point to the district court order, and it specifically remands this back for a very, very small reason. For the purpose of taking additional evidence as described herein, and that was to allow the consideration of the flight logs and also the department's assessment of sales tax payments made by petitioner to Wells Fargo Bank. And the order was just for that limited purpose. It was not to rehash the arguments that they already made. But the ALJ is very, very reasonable. And if you look at the transcript, the ALJ really actually did allow Mr. Bartlett yet a third bite of the apple and present those arguments again, even though the remand was for the limited purpose of allowing flight logs. And if you look, the very last order from the district court is, if the petitioner does not provide the flight logs for helicopters N2018R, N3180R, N62HP, and N173AL within 90 days from the date of this order, or 30 days prior to the date set for the evidentiary hearing, whichever is earliest, the rebuttable presumption against petitioner pursuant to NRS 47250 subsection 3 will become conclusive. They didn't produce the flight logs. It's conclusive. Now, he will argue that for one helicopter, they produced flight logs. These were actually log record sheets, and the department in their exhibit NNN, it's triple N, compared the flight logs to the fuel records, and they didn't match. And the ALJ found that this was just not enough to support their argument. And again, that's with respect to one helicopter. And if you look at the proposed decision on remand, and I keep saying, when I say ALJ, I mean administrative law judge, for the record. The administrative law judge did adjust the Wells Fargo payments, and she also adjusted the tax period for I'm sorry, it's for one of the helicopters. Okay, so it's so the court made adjusted it to just the lease payments after January 5th of 2015, but not before. So they were allowed to present this new evidence, even though it was outside of the scope of the remand. The administrative law judge did consider it. But with respect to the airlift did not provide flight logs for 3 of the helicopters, 2018R, 173AL, and 3018R. Therefore, pursuant to the First Judicial District Court's order, the presumption against airlift helicopters is now conclusive. The ALJ adjusted the audit with respect to the payments to Wells Fargo, and they also adjusted the time period for the lease of one of the helicopters. And again, I would just ask that the Tax Commission uphold the administrative law judge's proposed order, as it's a very well-reasoned decision, and it sticks to the scope of the remand from the First Judicial District Court. And I'd be happy to answer any questions.
Thank you, Ms. Nichols. Mr. Bartlett, do you have a short rebuttal?
Yes, just a short one. Well, recall there's even if you accept the department's arguments on N2018R, there's actually 2 issues with regard to that. Remember when I was pointing out that helicopter crashed on August 30th of 2013, and the department auditor continued to impose use tax at the rate of $9,000 a month on lease payments for that helicopter that were not being made after August of 2013. So we were not required to submit flight logs, I don't believe, for N30, I always get this wrong, 3180R, the helicopter that my client leased in September of 2013, because the department never taxed that lease in the audit. So at the very least, the administrative law judge should have removed those that part of the assessment, because you don't need a flight log to when it's documented the helicopter is crashed, is no longer flying, and that lease is terminated as a result. So there really is no factual basis, even if the so-called presumption applies that N2018R, should be subject to use tax on its lease receipts. Lease receipts ended in August of 2013, and there shouldn't be any more tax on those, on that helicopter. Again, N3180R was never taxed in the audit. The lease of that helicopter was never taxed. You will not see a reference to it in the auditor's schedules. Period. Why are we paying tax on it? Why are you not getting relief from that?
Okay, thank you, Mr. Bartlett. I'll bring it back to the Tax Commission for questions. I know we've seen this item several times, at least those of us that have been on the commission for a while. So is there any questions of any commissioners at this point?
This is Commissioner Byram. I have a comment. I understand the importance of the flight logs and of providing documentation and evidence when you're having an audit, so that the auditors have information to work with. But this just feels like playing hide the ball, and I think that once again the flight logs were requested. I think they could have been obtained, at least a copy of them, even though they aren't. They're no longer with the taxpayer. A copy would have been important. I don't find the fuel receipts to be very persuasive at all. There seems to have been more than one card number, unreliable information in those. I just think that this has been heard and resolved, and I would therefore move to uphold the hearing officer's proposed decision on remand from the district court.
Commissioner
Bursey
Lemon
seconds.
seconds the vote, seconds the motion. I defer to Commissioner Bursey.
I've got a I've got a motion by Commissioner Byram and seconded by Commissioner Bursey. Is there any other discussion from any other commissioners?
This is Commissioner Witt. Since I've been on this committee for a while, or commission, I found myself ruminating over these 616 pages. And I think I heard Mr. Bartlett say that the company is still doing things. I suggest that they get some kind of probiotic to stimulate accurate record keeping so that we don't find ourselves a little later down the line in the same conundrum that we continue to have. Just a comment. Thank you.
Thank you, Commissioner. Any other comments? Okay, I've got a motion and second. All those in favor, please signify by saying aye.
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 Is anyone opposed? Okay, motion passes. Mr. Bartlett, thank you so much for your time and your energy on this one. We appreciate it. And same to Ms. Nichols. Let's take about a 10-minute break. Let's come back at 10:35 and we'll stand in a break until that point. Thank you. We'll give it about one more minute. Looks like we're missing just a couple of commissioners here. So give me one more minute here and we'll see if we can grab everybody to reconvene. Ms. Hanson, the court reporter, are you ready to begin again?
I'm here and I'm ready.
Okay, thank you so much. Okay, let's go ahead and get started with the next item on the agenda. Director Hughes.
Item 4D, consideration for approval of proposed findings of fact and conclusions of law pursuant to the First Judicial District Court's order for remand dated November 16th, 2021, pursuant to NRS 233B.125 and NRS 233B.130. The item under this agenda item is Orthopedic Summit Association, Inc., and we have Andrea Nichols representing the department.
Okay, and do I have someone from the Orthopedic Summit Association?
Yes, sir. Jay DeVoy, present as counsel for Orthopedic Summit Association, Inc.
Thank you, Mr. DeVoy. Very similar last name. Could you spell that for the court reporter, please?
Sure, it is D-E-V as in Victor, O-Y. So four similar characters, but slight difference.
Okay, and just full disclosure, we are not related.
Correct.
In any way, shape, or form. Okay, very good. Okay, Ms. Nichols, could you go ahead and present the facts on this one for us, please?
Thank you, Chairman. Andrea Nichols, Senior Deputy Attorney General, appearing on behalf of the Nevada Department of Taxation. This matter was previously before the Commission in December of 2020. After considering the briefs, the oral argument, Mr. DeVoy presented a witness at that hearing. The Commission voted to uphold the department's denial of Orthopedic Summit Association's application for exemption from sales and use tax as an educational organization, finding that the primary purpose of the organization was to present seminars geared towards persons in the field of orthopedic medicine. The department or the tax commission's decision was sent to the First Judicial District Court on a petition for judicial review. It was sent back again from the First Judicial District Court for the small purpose of issuing findings of fact. As I said, there was one finding of the organization's primary purpose was to present seminars geared towards persons in the field of orthopedic medicine, but I believe the First Judicial District Court wanted a little bit more. If you'll look, I put in an Exhibit E, the proposed decision, and we would just ask that the Tax Commission adopt that proposed decision.
Okay. Thank you, Ms. Nichols. Mr. DeVoy, do you have a rebuttal?
Yes, sir. And for the benefit of the commissioners, I will try to keep this brief. What the prior decision of this commission and what the First Judicial District Court looked for was specific findings of facts and conclusions of law. And since this is on remand, the commission has the ability to examine the record again and arrive at alternate conclusions of fact and findings of fact and conclusions of law based on the record evidence that was previously submitted. The decision that the Orthopedic Summit Association exists solely as a trade show ignores the balance of record evidence that shows the nature of the summit that it does put on, and then the totality of the other activities that it has planned within the state of Nevada and continues to plan within the state of Nevada in conjunction with the Washoe County and the Clark County Medical Societies, and the ability to put on educational information for the members of the broader community and to inform students who might not otherwise be exposed to medical careers of the opportunity to work in that field and the opportunities available to them. This was all documented by Dr. Planter in his prior testimony and the materials that were submitted and resubmitted along with an alternate proposed findings of fact and conclusions of law that were in the Orthopedic Summit Association submission to this commission. Turning first to the purported trade show that the Orthopedic Summit Association puts on, it is an educational event. It is not an exhibition hall. It's not a place for people to buy and sell. It has cadaver labs. It has live surgeries being performed, and it trains physicians in order to provide these services using cutting edge technology, such as these Da Vinci machines that are used in hospitals throughout Nevada, in order to provide those services. That is only one component of what Orthopedic Summit Association proposes to do, and the rest is broader education for the community, including this Doctor for a Day program that is implemented in other jurisdictions and wishes to bring it to Nevada in order to provide educational opportunities to other people, and specifically to youths in disadvantaged communities that don't have friends who have doctors as parents, who don't know about the opportunities available in a non-physician role, such as being a physician assistant or an advanced practice registered nurse, and to be involved in the medical community and provide care to their communities where care is, as we've seen, underserved and not delivered with the same regularity as in other communities. That record evidence exists, and within making these findings of facts and conclusions of law and looking at the record again, Orthopedic Summit Association respectfully submits that this information be considered and an alternate decision be reached that grants the sales and use tax exemption going forward for all of its activities in Nevada, not just the idea that it is solely in existence to provide this trade show.
Thank you, Mr. Devoy. Is there any questions of the taxpayer or the department? Mr. Devoy, could you tell me how many days do you actually operate in the state of Nevada?
Orthopedic Summit Association, between the planned activities with Clark County Medical Society and Washoe County Medical Society, they had proposed about 3 per year in each of those. The Doctor for a Day would be an additional day, and then there would be the trade show that lasts for about a week. So all in, less than a month of activities. I don't want to put a specific range of dates on it, though.
Okay. All right. Thank you. Any questions from any of the commissioners of the taxpayer or the department? Seeing none, is there a motion? Nobody has any questions or comments? Okay. Is there a motion? Is there a motion that someone would like to submit?
It's Commissioner Byram. I would move to uphold the Department of Taxation's updated findings of fact, conclusions of law pursuant to the order or the matter of Orthopedic Summit Association.
Commissioner Witt, second.
I've got a motion and second to uphold the findings of facts and conclusion of law. All those in favor, please signify by saying aye.
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 Anyone opposed? No one opposed. Mr. Devoy, we're pretty consistent on this fact on the trade show front, and you know, I appreciate all of your time and your energy on this, and wish you the best of luck and continued success.
I understand. Thank you, Chairman.
Thank you very much. Executive Director Hughes, next item.
The next item is 4E, Taxpayers Appeal of Administrative Law Judge's Decision pursuant to NRS 360.245 and NAC 360.175. The item under this agenda item is Amigo Brands LLC, and we have Natasha Gabriel from the Attorney General's office representing the department.
Thank you. And is there someone from Amigo Brands representing them? Mr. Dushoff, you're on mute.
I thought I was doing it through the phone. I humbly apologize. This is Matthew Dushoff on behalf of Amigo Brands.
Okay, and could you spell that for the court reporter, please?
Sure. Last name spelled D as in David, U, S as in Sam, H, O, F as in Frank, F as in Frank.
Okay, very good. Ms. Gabriel, could you go ahead and lay out the case for us, please?
Yes, thank you, Chairman. Natasha Gabriel on behalf of the department. So just starting with the facts of this particular issue in front of us, The department received information from Amigo Brands themselves that they had inventory located at a Ready Ice storage facility. And what they were inquiring as to some sort of waiver documentation, I want to call it, stating that they didn't need a license to operate in our state. And this was for the purpose of a Washington state licensing agency. So the Washington state licensing agency saw that Amigo Brands operated inside of Nevada. And they're a Missouri company. I should clarify for the record, they're not a Nevada company. So they saw that at some point Amigo Brands operates within Nevada. Asked to see their documentation. Amigo Brands indicated that they didn't need a license to operate in our state, and Washington told them, please go get documentation purporting the same. Once Amigo Brands inquired to the department as to their operations, our investigator went ahead and asked a little more about their operations in our state. And what was relayed to the department was that Amigo Brands imports liquor into our state. The liquor is produced by a Mexican operated entity called ADS. Amigo Brands purchases the spirits from ADS, and the inventory is shipped to Las Vegas, Nevada. It typically goes to the ports first in New Mexico and or Arizona, and then is shipped into our state. And then the sealed totes through New Mexico go through customs, at which time Amigo Brands pays the federal excise tax on the product through their broker, Valencia International. Those sealed totes are then shipped to an entity that's called NLV Tequila Bottling, LLC. NLV Tequila Bottling, LLC then tests, filters, and packages the alcohol as Amigo Brands Bacanora Blanco, typically in 750 milliliter bottles. For the record, NLVT holds a liquor license as a rectifier in our state. Once NLVT completes packaging the liquor, Amigo Brands arranges transfer of the products from NLVT to Ready Ice for refrigeration and storage. And once Amigo Brands wholesaler, Southern Glazer Wine and Spirits, places an order, then Amigo Brands arrange for shipment, arranges or directs Ready Ice to arrange the liquor for shipment or for pickup from Southern Glazer. And for the record, Southern Glazer and Wine Spirits is licensed as a Nevada wholesaler. On December 8th, the department conducted an inspection at the Ready Ice warehouse, and they found, the investigators found 58 pallets of Amigo Brands liquor contained at the warehouse. Ready Ice does not hold a Nevada liquor license, and so the storage of the liquor was in direct violation of Nevada law, and the department seized the liquor in place. Petitions for claim on the property were provided to all three entities, Amigo Brands, NLVT, and Ready Ice. Amigo Brands filed its petition for the claim on the property, claiming ownership of all pallets of liquor that were seized. And the matter went to administrative hearing, and ALJ Smith presided. ALJ Smith held that Amigo Brands failed to meet its burden by the preponderance of the evidence, that the seizure was improper, and denied Amigo Brands' request to have the liquor returned to its possession, as they are unlicensed and unregistered in our state, or they were at the time they were operating. Once ALJ Smith issued her decision, within the decision, it was, I should clarify, ALJ Smith allowed Amigo Brands the chance to submit documentation as to the liquor that came from a Florida supplier. The liquor that came from the Florida supplier was already in its complete form. So it was ready for consumption and to be sold to a wholesaler. And all of that happened in Florida. And so that liquor was only shipped improperly into our state. The Amigo Brands did submit that documentation and the department accepted it. And then this appeal followed. I should mention that on January 14th, 2022, the department went out to the Ready Ice location where the liquor was seized. And the reason they were out there was because per the conditions enumerated in allowing the Florida liquor to go back, we stated that the department needed to be present when the liquor was going to be shipped out. While the department was out there, the investigators actually noticed that there was more Florida liquor and it was not part of the seizure because the department didn't see it nor know about its location. The department seized the Florida liquor at that point properly because Ready Ice was still not a licensed liquor holder of any sort. However, knowing that the Florida liquor that was a part of the second seizure was substantially similar to the original Florida liquor that was seized, the department I'm not sure if that part of the Florida liquor has gone back yet to the Florida shipper, but the department did allow for that to happen. So all of the liquor that was seized on those two occasions that came from the Florida supplier called Mango Bottling is being allowed to go back to that Florida supplier. What we believe on appeal in front of you here, based on what the taxpayers have submitted for consideration, is that they do not disagree with the seizure at this point, but they would like liquor that was seized from a Wisconsin supplier to be treated the same as the Florida liquor. The department and ALJ Smith disagreed with this argument because they are inherently different products. The Florida liquor was in its final stage, and so it was still improper to ship it into our state. However, it was at least in its final stage, so that department can be comfortable. Just you shipped it into our state, you can have it back. The Wisconsin liquor is actually base raw material. It's not ready for consumption yet. It still needs to go through further processing, if you will, through the rectifier to then be ready for.
I'm sorry, you froze up there.
Sorry, I'll go back a little bit. So the Florida, oh, sorry, can you hear me? Yeah. Okay.
Yes.
Okay, sorry about that. I got a connection failure for a second. So the Wisconsin liquor is not just they shipped into our state unlawfully and they were ready to sell unlawfully. There's an extra egregious step that was taken here. It's raw material. So now you're importing into our state improperly without a license. Then you're making liquor. So you're getting something to a final stage to be consumed in our state without being licensed. And then you are selling that liquor through an unlicensed location to a wholesaler. So that extra egregious step there is what differentiates the Florida liquor and the Wisconsin liquor. And the department asks that this commission follow ALJ Smith's logic here in that with the Wisconsin liquor and the Florida liquor should not be treated the same, and the Wisconsin liquor should be disposed of as ALJ Smith's order directs.
Thank you, Ms. Cabral. I appreciate it. Mr. Duchamp, do you have a response?
I do, thank you.
Thank you.
We understand that in order to have the hearing officer's ruling reversed, we would need to show violation of constitutional statutory provisions, excess of statutory authority made upon unlawful procedures, affected by errors of law, or that it's clearly erroneous or arbitrary and capricious. Frankly, as someone who worked for the Attorney General's office for 10 and a half years under Frankie Sue Del Papa and Governor Sandoval, as I am now dating myself on that, I know that that burden is very, very high. But in this case, unlike the cases that you have heard previously today, we're not asking you, as was stated by counsel, we're not asking you to overturn the ruling. We're asking you to permit the return of the bulk Wisconsin Galloway cream and rum that is, understand, in a sealed and complete form. This is not brought in by Amigo. And we know that the Nevada law allows the bulk and distilled spirits to be imported. The Nevada law's NLVT to rectify that product. But you need to understand, this product was never sold. This product was never even open. If you see pictures of it, it's still sealed, manufactured. It's shrink wrapped and still in its box. And what we're going to ask you to do under NAC 360.175 sub 6 and NRS 369.420 is to use your discretion, is that this be shipped back to Wisconsin, just like the Florida liquor was shipped back. It's still sealed, just like the Florida liquor. It's still in its complete form. So I want to go into this just a little bit. We agree Amigo should have had a certificate of compliance. Amigo was a supplier, as defined under NRS 369.111. Amigo shipped the tequila, and Wisconsin shipped the cream to the rectifier pursuant to 369.415, which says that a rectifier can accept bulk materials, which is what this Wisconsin cream is. It is a bulk material. So I want to make sure, because I understand from the previous hearings and to know from my past knowledge, that from the information we received, it is our understanding that all the excise taxes for the rectified liquor was paid to the state. There was no subterfuge. There was nothing that was hidden in regards to the taxation. There was no avoidance of the taxation. And I can't emphasize that point enough, that is our understanding from the information we received from NLVT, that the excise taxes were paid to the state, not just federal, but to the state for the rectified liquor. The product was stored at Ready Ice. As we now know, they didn't have a license to store the liquor. The only one who knew that at that time was Ready Ice. They told us, and they told NLVT that they had the right to store the liquor. So arguably, it is Amigo's responsibility to know Amigo relied on the word of Ready Ice, but Ready Ice did not have that license. So the department itself only discovered this issue when Amigo, as counsel said for the AG's office, that Amigo themselves came to the department. And it wasn't something that there was an investigation or Amigo was hiding this. Amigo thought it was doing everything properly. And Amigo came to the department, and then the department realized, hey, wait a minute, you can't do this. What we're asking in this case, as stated earlier, is to use your discretion. given pursuant to NAC 360, .175 sub 6 and 369.420 regarding any shipment of liquor which cannot be received or accepted by the consignee for any reason in law may be seized by the department or its agents and held subject to the order of the shipper for its return at the shipper's expense. Pursuant to 369.420, the department permitted Amigo to ship back the Sonora Bacanora Blanco, which was in a 100 milliliter bottle, the Sonora Creme de la Bacanora Mocha, also in a 100 milliliter bottle, and the Sonora Creme de Bacanora Pineapple Colada at 100 milliliters back to Mango Bottling in Florida. Well, the rationale behind this decision was that the bottles were sealed and manufactured in Florida, so they're easy to trace back. Well, we're just asking for the same treatment regarding the Galloway cream and rum that is still packaged and, most importantly, unrectified. We're asking that the shipment be returned to Galloway, Wisconsin as well. Well, the department argues that the shipment from Wisconsin is somehow more egregious than the bottles from Florida, but I can't see that. Except for the size of the shipment, 100 milliliter bottles, as opposed to the bulk package, which the rectifier can get at 1,000 liters. Well, we know 1,000 liters is more than 100 milliliters, but that's the difference. The size. The Galloway cream is still in its manufactured sealed container, just like the Florida product. There is no secondary market for the Galloway cream. It's not something a Nevada wholesaler can purchase and sell at a profit. And you can't pour 264 gallons of cream down the drain or sell it at an auction because, again, this is not for secondary consumption. The Galloway cream can be traced back to the original source. The Galloway cream was not rectified. The destruction of this product should only be used when there are no other tracing or return of product that you can do. No one benefits from the destruction of this product, neither the state nor the taxpayer. So understand that if you look at this cream and you look at the pictures of the box, of the 264 gallons, it is sealed like the Florida one. And maybe the issue is that it's hard to understand because we don't do a lot of this. You don't see a lot of this. But this product was sealed. It was never opened. This is the same type of product that you allowed Florida to go back. It's just in a much larger volume. But I want to talk about the rectified product a little bit. And we received correspondence from NLVT that they are willing to store that product, and they also have the license to do that. We're asking that that be sent back to NLVT. This product was properly rectified by NLVT, and they are a Nevada licensed rectifier. The only issue here is what we're talking about is paperwork, right? We're talking about a certificate of compliance, which is $50, and the renewal fees. Amigo understands it was wrong and takes responsibility for its actions. However, if you don't allow the Wisconsin cream, again, that's already sealed, much like the Florida product, to be sent back, you're talking about a $110,000 penalty for this matter. And that just does not fit the crime here. We ask pursuant to NRS 369-420 that the commission does use its discretion to at least permit the unrectified shipments to be shipped back to Wisconsin. And if the commission sees fit, to allow the rectified product to be returned to NLVT or allow even the unrectified product to return to NLVT, who is a licensed rectifier. Now, we're not saying that Amigo needs to go unscathed. No, we understand that they committed a violation. And in this violation, they should pay a fine. This is money that will go back to the state. The state will benefit from this. The state would not have to figure out a way and cost to destroy 264 gallons of cream, because again, that has been unopened. But to issue a fine, taxes were collected on this matter. We're asking for issue a $10,000 fine, or if the commission seeks an additional fine an additional fine on that matter. The department would get money, and the department would not have to absorb the cost of destroying the 264 gallons of cream. Thank you.
Thank you, Mr. Dushoff. Ms. Gabriel, do you have any rebuttal?
Yes, thank you, Chairman. I'd like to address a few of the points that council brought up. First, the department has not received any sort of documentation to corroborate the statement that NLVT would have paid taxes on product that's not theirs. Amigo Brands itself has stated on numerous, both in the hearing and in their documentation in your packets, that the ownership never changed. NLVT as a licensed rectifier, yes, they're licensed to rectify here, but they never at any point have owned this liquor. And so it was caused to be imported into our state improperly because it was Amigo Brands that held ownership. If they held ownership, it was caused to be imported improperly because they are not licensed in our state. Therefore, NRS 369-450, subsection 3, to be imported
Ms.
improperly.
Gabriel, sorry to interrupt you. Cut out there again right after the NRS.
Okay, can you hear me now?
I can hear you fine. You just froze there.
Okay, great. Sorry, I got that notification again right when you said it that my connection was bad. I apologize. So NRS 369-450 subsection 3 here applies. It says that you cannot cause to be imported improperly into our state without a license alcohol. And so if you violate NRS 369-450, then this commission can use its discretion to apply NRS 369-460. And 460 sub 2 states that we do not at the order of the shipper have to send back the liquor. We can auction it off, and then if we don't auction it off, we can dispose of it. And the Wisconsin liquor.
I'm sorry, you froze up after dispose of it.
Dispose of it. Okay, we ask that this commission dispose of the Wisconsin liquor in the manner that ALJ Smith directed, because it is differentiated. Yes, we allowed the Florida liquor to go back, and it was a consideration that documentation could be provided to trace it back, but that was not the only consideration. We did also consider that this company alerted us to the fact that they were operating in our state improperly, and that they were the ones that inquired, and it wasn't an investigation on our part initially. And so that was a consideration to allow them to get some of the Florida liquor back, because there was a representation that this liquor is all of this company's liquor. And so that was a consideration there, but the Wisconsin liquor it's just not the same, because again, it's not ready to just go to wholesale. It wasn't branded and bottled and ready to go with the Amigo Brands label right from Wisconsin. Something had to happen here first, and to send it to NLVT was improper because ownership never changes. And so it's an improper co-signee because Amigo Brands did not operate in our state. I also wanted to address that Ready Ice, while they asked Ready Ice if they can store the liquor, And that was taken into consideration. Again, Amigo Brands, there's no indication that they asked a Nevada attorney, that they called the department and asked whether they can operate in our state without a license. And at the end of the day, they did operate for over 3 years in our state and profited from that. And upon information and belief, there were no taxes paid besides the federal excise taxes. And so for 3 years, this company profited from being unlicensed and unregistered within our state, which puts our licensed and registered businesses at a great disadvantage. And so while we gave consideration about the Florida liquor, the Wisconsin liquor is not the same just because it is sealed. Thank you. That's all I have.
Thank you, Ms. Gabriel. Mr. Dushoff, do you have any final comments before we go back to the commission?
I do, very briefly. In regards to the tax issue, we do have records that the excise tax was paid by Nevada licensed rectifier, which is NLVT. If there was a tax issue, I would like to think that that would be one of the first things the division would have brought up, going, wait a minute, we have all this liquor coming in and nobody's paying taxes on that. That's because there wasn't an issue. If there was, that would have been the first thing on the hit parade that they would have brought forward. In regards to the gallons, I guess I miscalculated my liters. I'm not very good into my liters into gallons. What they actually have is 6,000 gallons of the cream from Wisconsin, not 240, or 260. So I apologize. So you'd be getting rid of 200, you'd be getting rid of 6,000 gallons. And what the state explained is that it's no different except for the size. That's all it is. It can be traced back to Wisconsin. It can be sent back to Wisconsin supplier at Amigo's cost. So you just send it back. It hasn't been opened. It hasn't been touched at all. It's in its same package. So it hasn't been rectified. So it is the same, just on a much larger scale than the milliliters. And you do have that discretion to do so. And that discretion is used in certain situations like this, where it hasn't been opened, that you can trace it back to the supplier and give it back to the supplier, because nobody else benefits from this. Nobody, the state nor the taxpayer benefits from the destruction of this. And because we can trace it back, we're asking to trace that back, to be able to give out, to send it back, and frankly, issue a fine to Amigo. We're not challenging the ruling. We're just asking in this case to use the discretion that you have to be able to say, hey, listen, you know what? We could trace this back. You guys sent back the Florida ones. This is raw material. You can send this back just as well because it hasn't been touched. So one moment. And it's my understanding that I believe that I listened for my client that at the hearing, Amigo did provide proof that the taxes were paid, but we've seen the proof that taxes were paid. And again, the argument being made that if taxes were not paid, that would definitely be something that the state would have looked at, probably the first thing they would have looked at. So all we're asking in this, give the opportunity, it's $71,760 to be sent back. That's a lot for something that if they had a certificate of compliance, that would have been $50 and renewal fees. So what we're asking is give the opportunity to ship that back. And for the rectified materials, give it back to the North Las Vegas tequila, because they are the licensed rectifier. Thank you.
Thank you, Mr. Dushoff. Is there any questions of the taxpayer or the department at this point?
Chairman, if I can just make one clarification for the record.
Yes.
I would like to clarify that the department did not receive evidence that NLVT paid taxes on behalf of Amigo Brands, but I would like to state that that is an ongoing investigation currently to ascertain that fact.
That should actually be fairly easy to figure out, though. Would you agree?
whether,
seems-
whether.
That seems like that would be very easy to find whether they paid the taxes on this product or not. Would you
Right,
agree?
if they at least identified, hey, we're paying taxes on behalf of another company.
Okay.
But because they never switched ownership, I think that's what's making it a little bit blurry, is that we see that NLVT paid its taxes, but did it pay taxes on its own product or Amigo Brands? We can't see there is no distinguishment, is what I should say.
Okay, very good. Is there some questions from the commission at this point? Commissioner Byram.
Yes, I do have a question. There's a footnote on, in our document, it's 140, page 140. There's a footnote that talks about the three-tiered system and that there was a pending advisory opinion at the time to see if Amigo Brands was occupying one or more of those levels within the state. And so my question has to do with, are they now currently correctly registered and licensed for handling liquor in the state? What tier levels are they registered with? Are they in compliance going forward?
Commissioner Byram, upon information and belief from my investigators, a certificate of compliance was issued to this business, which then in turn means they are now registered with the department. However, the matter is being investigated further because we believe the certificate of compliance was issued in error.
Why would that be?
We believe that, well, first, the address was incorrect. I believe they listed a North Las Vegas address, but stated Missouri as the state, and it got issued in that way. So that was error. That was the first error. The second one is we believe that they listed that NVLT address as their address, as their licensed address, and because of the three-tier system, that is disallowed because a rectifier can't also be a wholesaler or fall within one of the other tiers.
Okay. Okay, I think that was the only question I had. Thank you.
Thank you, Commissioner.
Is there any other questions?
Commissioner Wren?
Commissioner Wren, go ahead.
Oh, okay. Thank you very much, Mr. Chairman. So I'm just trying to figure out how Ready Ice actually is playing into the whole scheme of this thing. It appears that Ready Ice is unlicensed to handle this, but has accepted shipment of this product. And I'm assuming through this whole process is still receiving rental payments or storage payments on it. I'm just kind of wondering how that plays into this scheme of things here. I guess the question is to the state, I guess.
Thank you, Commissioner Wren. So Ready Ice, the reason that from what we could gather from the hearing documents, NLVT doesn't have the space to, after they've rectified the liquor, they don't have the space to then store that liquor until such time that Southern Glazer is ready for a purchase order. And so Amigo Brands arranges for the rectified and completed liquor to go to the Ready Ice storage facility. And I believe that there is sometimes where Ready Ice takes shipment directly if NLVT doesn't take shipment directly in some cases. Sorry, that's not very descriptive, but I believe the only information we had is that sometimes Ready Ice not only gets the rectified product from NLVT, but it also sometimes gets it directly to them until NLVT is ready to rectify. So there's kind of this back and forth. However, what's important to note is that Ready Ice is not licensed to store this liquor in any way, shape, or form. They are not a wholesaler, a rectifier, a manufacturer, an importer. They are none of the above, and they're a storage facility only. And Nevada does not issue separate liquor storage license. You either have to be an importer or a wholesaler. And as part of being a wholesaler or an importer, you are allowed to store liquor. I hope that answers your question.
Yeah. Sorry about that. Go back where you. Yes, I think so. But Mr. Chairman, my only other comment on this, and I'm kind of leaning in the direction that maybe it makes more sense to have this product sent back and fines put in place to benefit the state of Nevada. I don't see the benefit to the state of destroying this product, to be really honest. So it's just my upfront thoughts. Thank you.
Thank you. Ms. Gabriel, Ready Ice seems to have an awful lot of liability associated with this, in my view. There's a couple of, I'm kind of leaning towards Commissioner Wren. And the reason I'm doing that is because these guys self-disclosed. You would not have known this without their disclosure at all. So that's a pretty mitigating factor from my standpoint. And the second one is I read the Bob Reeder emails back and forth, and it felt like to me that he was not trying to play hide the ball here at all. He was trying to do whatever the right thing was. So I think Ready Ice, is there any liability associated with this storage facility? I understand what you're saying on the storage part, but when you've got a whole bunch of product that can't be stored in a cold facility that needs to go somewhere, and they purport that they're able to do this, what's their culpability in this whole sordid mess?
Thank you, Chairman. Under statute, if you cause to be imported or store liquor that's improper, it can be a misdemeanor. So there are criminal punishments should the Office of the Attorney General choose to prosecute such a crime. I believe it's a misdemeanor if we would charge under. I don't know as of right now if the Attorney General's office is inclined to go after Ready Ice criminally. There isn't a civil penalty that comes associated within Chapter 369 for this conduct. I believe the department is investigating Ready Ice, but that's going to be
okay.
That's
all
going
right.
to be, but it could be also be a civil matter between the parties. But as far as the state, I believe it's only criminal that we can.
Well, it feels like Amigo Brands has some ability to go back against Ready Ice for their conduct as well. So is there any other comments or questions from any of the other commissioners?
Commissioner Lippman.
Yes.
Mr. Dushoff, why would NVLT, I think is the acronym of the company, why would they pay taxes on products they don't own?
Well, that is a very good question. They paid the tax. They paid the taxes, the excise tax, after they rectified it and gave it over to the wholesaler. Why they did that? Our client reimbursed them for the taxes to be paid. So it really wasn't coming out of NLVT's pocket. It was coming out of our client's pocket, reimbursed them. But we knew that somebody had to pay the excise tax, right? You can't just do this without paying for it, because, like I said, that would be the first thing that the Department of Taxation would look at. What our client did, what Amigo did, is said, okay, NLVT, you paid $3,000 for this. Here you go. Here's the check for $3,000 to reimburse you for that. I hope that answers your question.
It does. Thank you. And a follow-up question. So on a going forward basis, how is Amigo storing these products if they don't have the capacity and NVLT doesn't? I assume you're not continuing to use Ready Ice.
You asked an excellent question. So yes, we will not, the only reason it's stored at Ready Ice right now is because they don't want to move it. The Wisconsin product has to keep chilled and you don't want to move it from there. However, I have a letter here dated January 19th, 2022 from NLVT saying that they do have the capacity to store the Sonora Bacanora Blanco, the Mocha, and the Colada, and the 23 pallets of the raw material, Galloway cream, that they do have that capacity, that they will do that. So I have an affirmative letter from them that they can do that once it's taken out of Ready Ice, because frankly, it has to get taken out of Ready Ice. As the state most eloquently stated, they don't have the license to hold this.
And then do you have any sense, you used an example of $3,000 as the amount of the excise tax. I don't know if that was that just exemplary, or what was the amount of this excise tax paid, more or less?
Right, more or less around $8,000 is the information just received from my client.
And then Amigo now has some sort of licensing, although it sounds like that still is potentially an issue just because of some details on the form filed. So do you not have an address in Nevada?
We haven't. What we're going to do is we're going to modify. We're going to use the address in Missouri because that makes more sense in order to be considered a supplier into the state of Nevada. Be the supplier, ship it over to the rectifier, where the rectifier will now own the product. We won't own the product. They will own the product. Why? Because that's what you're supposed to do. They will own the product, and then the rectifier, can ship it to the wholesaler or do what they want with it, because now they own the product. So we're getting that taken care of. We're now in the process as counsel. I'm sorry, I'm staring at my screen instead of at the video, so I apologize. We now have the certificate of compliance. We know that it was issued by the state. We're going to make the changes and make the modifications to put the Missouri address on there, so we're an out-of-state supplier and we're conforming with all the rules. As the chairman so eloquently stated, we don't want to serve our client by saying our client doesn't want to circumvent the laws, wants to follow it and understands what it needs to do now, because now it came to us and now it understands what it needs to do. So that's what we're going to do moving forward, if that helps answer your question.
Yeah, so as you know, the state does not necessarily have to destroy this product. The state could, as Ms. Gabriel said, auction it off. What is the reality of actually doing that?
So the reality of auctioning off 6,000 gallons of cream is not like the reality of selling already processed liquor, where a wholesaler, as a state, we have a lot of wholesalers, large ones, who would come in or buy it. No wholesaler is buying bulk. The chances of selling this, in our experience of being liquor, would be slim and none. And so it would come down to having to destroy 6,000 gallons of this. So there wouldn't be a rectifier to buy this. What it would be in most cases where this happens is that it's already bottled. And so you can put it at auction and you can sell it to any one of the number of wholesalers that are here that would be at auction to purchase it. But again, this is bulk material of 6,000 gallons of the mixture that hasn't been opened yet.
And so if the commission agrees to let this go back to Wisconsin, the taxpayer or Amigo brands will suffer some consequences from the unrectified product. Is that true?
That is true. That is correct. About $32,000. I bet you. I don't know if that was your next question, so I apologize if I interrupted.
It was. So thank you. Thank you for that. It's very helpful.
You're welcome.
Any other questions from any of the other commissioners? Is there a motion that one of the commissioners would like to make?
This is Commissioner Wren. I'll take a shot at it.
Okay.
I would, Mr. Chairman, I would move that we have this product shipped back to Wisconsin through the appropriate tracking means, and that we further fine Amigo Brands $15,000 in fines to be paid within 60 days.
And that, just to clarify, there's more product than just the 6,000 gallons of cream. The rest of the order would stay in place. Is that correct?
Anything that is illegally in that shipment needs to be shipped back.
Okay, just so I'm clear, so the 6,000 gallons of cream would go back. Everything else would stay seized by the department, the state of Nevada.
Yes, sir.
Okay. Is there a second?
I would, this is Commissioner Bursey, I would second it, but I have a question. With the 100, some part of the liquor has already been shipped back. Is that my understanding correct?
Yes, Commissioner.
Florida. Oh, I apologize. Go ahead.
Oh, that's okay. Not a problem at all. Yes, Commissioner Bursey, the Florida liquor that was seized originally and on January 14th has been sent back. Attorney Dushoff, if you can clarify whether that January 14th, when that was seized and we allowed that to go back, if that's actually gone back, I'm not sure, but department has agreed to allow it to go back.
Yes, and it is in the process. It's not, I think we have the information that it's already being shipped back. And what we're talking about is the ones from Mango Bottling, the Sonora Bacanora Blanco 100 milliliters, the Sonora Creme de Bacanora Mocha. It's also been 100 milliliters, been shipped back. And the Pineapple Colada, which is Mango Bottling, has also been shipped back to Florida.
Mr. Dushoff, of the 40 or the 58 pallets, how many pallets were shipped back to Florida? Maybe that's what Commissioner Bursey and I would love to know.
31 pallets. I'm doing remedial math, but I believe that's 31 pallets.
So 27 pallets remain that are going to be seized by the state. And then whatever the second shipment was is going back. So 27 pallets is the difference that's going to be remains seized by the state.
Right, and 23 pallets is made up of the cream.
All right.
Okay, all right, then I second the motion as it stands.
Okay, so I've got a motion and second. Any other comments, discussion? Seeing none, all those in favor, please signify by saying aye.
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 Chair votes aye. Anyone opposed? Okay, make it so. Thank you, Mr. Dushoff, for your time today. And Ms. Gabriel, thank you for your time as well.
Thank you.
Thank you very much.
Okay, the next item is the consideration of the permanent regulation LCB file R130-21. Director Hughes.
Yes, the next item on the agenda is item 5.1, consideration for the adoption of permanent regulation LCB file number R130-21, a regulation relating to taxation, establishing provisions for the administration, calculation, and payment of tax imposed on the Nevada gross revenue of certain entities engaged in the business of extracting gold or silver or both in this state and providing other matters properly relating thereto. I will be presenting for adoption today, proposed regulation LCB file number R130-21 with the department's proposed changes. For the record, my name is Shelley Hughes, Executive Director for the department. Before I begin my review of the regulation, I wanted to start out by giving the Commission some background information. After Assembly Bill 495 was passed during the 2021 legislative session, we had several meetings with the Nevada Mining Association discussing implementation of the bill. The Nevada Mining Association provided us with draft regulatory language on or about October 14th, 2021. The department made slight revisions to this language, adding in some provisions for the administration of the tax. And we submitted our draft language to the Legislative Council Bureau, or LCB, and LCB prepared the original draft of LCB file number R130-21, which was returned to the department on or about December 23rd, 2021. It's important to note that LCB reviews the language provided and determines if we are acting within our authority. If our draft language contains actions which are not within our authority, LCB will not include that language in the proposed regulation. Once we received the proposed regulation back from LCB, we scheduled a workshop for January 10th, 2022 to solicit input on the regulation. We received 2 public comments, one written and one verbal at the workshop. After the workshop, we took those comments into consideration and made some revisions to the language. The draft you have before you today contains those revisions. Because the provisions in LCB file number 130-21 provide or pertain to the administration of the gold and silver excise tax, which is due April 1st, 2022, the regulation should be adopted sooner rather than later to that date. The regulation must be heard by several commissions before it can become effective. The first commission is this body, the Nevada Tax Commission. This commission hears the regulation and chooses whether to adopt the regulation. The second commission to hear this regulation is the Mining and Oversight Accountability Commission. This commission is not required to adopt the regulation, but they will review the regulation and provide a report with its feedback on the regulation to the Legislative Commission. The third and last commission to hear this regulation and review it will be the Legislative Commission, and they will determine whether to approve it and whether it requires changes. Based on the need to present the regulation to each commission and the scheduled date of each commission's upcoming meetings, it was necessary to hold the adoption hearing at this tax commission meeting. I would like to walk through each section of the regulation and briefly discuss the revisions that were made. LCB file number R130-21 establishes provisions for the administration, calculation, and payment of the tax imposed on the Nevada gross revenue of certain entities engaged in the business of extracting gold or silver or both in this state, pursuant to Assembly Bill 495. Sections 1 through 6 provide for the administration of the gold and silver excise tax by the department in the same manner as other taxes we administer. Section 7 adds Chapter 363D to the NAC. Section 8 indicates that the words and terms defined in sections 9 and 10 of this regulation have the meaning ascribed to them in those sections. Section 9 defines the gold and silver excise tax. Section 10 defines the Nevada gold and silver excise tax return. Section 11 specifies the first taxable year for the gold and silver excise tax and each subsequent calendar year pursuant to sections 17 and 62 of Assembly Bill 495. Section 12 interprets the term fiduciary duty for the purposes of a deduction from the gross revenue of a business for the revenue of a business entity that is required by fiduciary duty to be distributed to another person or entity pursuant to sections 14 and 26 of Assembly Bill 495. Section 13 interprets the term intangible investments for the purpose of the exemption for the gold and silver excise tax for a person whose activities within the state are confined to the owning, maintenance, and management of the person's intangible investments or of the intangible investments of certain persons or statutory trusts, or business trusts pursuant to Section 4 of Assembly Bill 495. Section 14 establishes the circumstances under which a good or service is provided on a complementary basis for the purpose of the exclusion of the value of such goods or services from the gross revenue of a business entity pursuant to Section 10 of Assembly Bill 495. Section 15 specifies the records that a person responsible for maintaining the records of a taxpayer is required to keep for the purposes of determining the amount of tax owed by the taxpayer. In this section, based on comments we received, we revised Section A to clarify that the record be a general ledger with transaction detail for gold and silver revenue accounts. And we deleted item K regarding inventory records. Section 16 requires a business entity subject to the gold and silver excise tax to use the same method of accounting for the purposes of the tax as the business entity uses for the purposes of its federal income taxes. Section 17 clarifies that the gold and silver excise tax is a tax imposed on the Nevada gross revenue of a business entity engaged in the business of extracting gold or silver or both in the state, and establishes when a business entity is subject to the tax. Here we clarify that any gross revenue that is received from a subsidiary is pass-through revenue and is not subject to the excise tax. Section 18 establishes the types of business entities that constitute a business entity for the purposes of the gold and silver excise tax. Here we deleted language that would not apply in the imposition of the gold and excise tax. We added clarifying language to paragraph G to avoid any contradictory provisions, and we added the definition of a subsidiary. Section 9 establishes the manner in which a business entity is required to convert a foreign currency into United States dollars when a contract for the sale of gold or silver or both establishes the sales price for gold or silver in a currency other than the United States dollar. Section 20 requires a business entity that is engaged in the business of extracting gold or silver or both to file with the department a Nevada gold and silver excise tax return on or before the due date established by Section 25 of Assembly Bill 495. Here we added clarifying language to discuss what is included and not included in a business entity's gross revenue. Section 21 clarifies when the department may waive all or part of the penalty or interest or both imposed on a taxpayer for failure to timely pay the tax. Here we added clarifying language that we may waive penalty and interest or both under the grounds set forth in NAC 360.396. We deleted all other language as it was mistakenly included in the original language and is irrelevant. Section 22 provides for the payment under protest of the gold and silver excise tax without the waiver of any claim relating to the amount of tax due. And Section 23 provides that the rules for citing the gross revenue of a business entity to Nevada for the purposes of the commerce tax apply to the citing of the gross revenue of a business entity to Nevada for the purposes of the gold and silver excise tax. This concludes my review of the regulation with the proposed changes. Today, we ask for the Commission to adopt LCB file number 130-21 with the proposed changes, and I'm happy to answer any questions.
Thank you, Director Hughes. Before we start, I received my latest copy of this at 8:40 this morning, 20 minutes before the actual meeting. Is there significant changes from this document from what was in the original?
Thank you, Chairman DeVold. No, there were just very minor changes. The definition of subsidiary was listed under the incorrect section number, and so it was put under the correct section number. And then there was some clarifying language just to clarify that a business was defined as a business who extracted gold or silver, or both.
So there were no other significant differences from the document that we had a week ago?
There was a document with the department's proposed changes that was provided at the end of last week. And this is just an update to those proposed changes.
Okay. Before we start discussion, I've got a disclosure to make. I believe Pete Ernott is one of the, I don't know if he is a lobbyist or he's somehow engaged with the mining industry. I've had several conversations with Mr. Ernott, and it's Mr. Ernott is a client of my employer and someone I regularly deal with. I don't think I've got any conflict associated with that, but he did attempt on several occasions to have discussions with me on this regulation, and I just wanted to disclose that and make sure that people understood, number one, that he's a client of my bank and that I regularly have conversations with Mr. Ernott, that this topic did indeed come up on several occasions. So anyway, but I do feel like I can be objective and not have any undue pressure from that conversation. Is there any other disclosures that anyone else would like to make? Okay, seeing none. Let's go ahead and are there any questions from any of the commissioners to the department? At this
Commissioner Lippman, I did just want to mention, and I'm not sure because there have been so many, obviously, this commission is very document intensive, but it does seem to me that the document that we had in our initial distribution, and again, I apologize if this is not correct, did not have a number of comments integrated that Commissioner Byram had provided, which I appreciated, very detailed page and section number suggestions. I don't believe those were integrated into the document that the chairman was describing from a week ago, but it does appear to me that they are now integrated, and I appreciate that. Most of them, Executive Director Hughes, I agree, are clarifying just to make sure that it's clear that the assessment is on businesses engaged in the business of extracting and selling gold or silver. So just clarifying language. But I believe that, there were a lot of some deletions, as you described, that came from Commissioner Byram's kind of point list, which I greatly appreciate. So I'm thankful that the department did that because Commissioner Byram spent a lot of time and energy going through every section in detail. So I appreciate that clarification, but I think it is a different document than the one that was in our original file, I believe.
Yeah, I agree. I believe we've got someone from the mining industry. I think there was some comments associated with that, and if they could identify themselves and maybe have some comment prior to any further discussion. Is there someone from the mining industry online? I see Mr. Gray has his hand raised.
Greetings. Greetings, it's Tyree Gray. Just want to confirm that you guys can hear me okay?
Yes, thank you.
Wonderful. Well, thank you, Chair and members of the Tax Commission. My name's Tyree Gray. I'm the president of the Nevada Mining Association. And today I sit here representing the 37,000 hardworking Nevadans that form part of the mining supply chain. I think, in way of background, I'd like to thank Director Hughes and really her staff for taking the time to work out this these regulations. I think it's important to recognize that AB 495 was a product of hundreds of hours of discussions between the mining industry, the legislature, the governor, and the Nevada education community. And the intent of it was to produce one thing: additional funding for K-12 education while preserving the viability of Nevada's foundational industry. And so though we applaud a lot of the work that has been done, we do believe that there's a couple of minor switches, and again, that can be made and that this commission has the authority to do so. And so I will limit, if I may, just to 3 areas. Area number 1, the collection period for the taxes that will eventually be due in April of 2022. The revenues that are subject to collection and by whom. And number 3, the naming of the tax that is created by AB 495. I'll take them in reverse order really quickly. The naming of the tax, again, it has been called the gold silver extraction tax, and a lot is in a name, and the naming of this tax really matters. Governor Sisolak said that the passage of AB 495 will provide meeting and dedicated investment for every educator and student. Speaker Frierson went on to say later on that AB 495 represents unprecedented collaboration, and this bill ensures that we have the resources to fund education at a record level that our children deserve. And I could go on and on with comments around this, but I think it's important to recognize that education is the beneficiary of this tax. And there's no clearer way to do that than to make sure that the term education is included in the name. There's really no reason for that. So as such, we have suggested that there be a change to Section 9 that would replace the gold silver extraction tax with the name mining education tax, and then obviously then all references to that be changed accordingly throughout the regulations. Number 2, who pays the tax and on what revenues? I think it's important to recognize that in order to be subject to this tax, a person must meet really 2 criteria. Number 1, you must extract gold and silver within the state of Nevada, and then number 2, you must sell the gold and silver that was extracted. And I think that it's important to recognize that because there are companies who may perform on a contractual or a contractor basis that may extract minerals or may even sell minerals, but they have no rights to receive the revenues from that. They're just a third-party contractor. And so we want to make sure that those companies don't get swept up within something that they're not intended to be a part of. And as a result of that, we have, again, just wanted to echo the amendment that there be that be placed in page 14, section 17, 1A, that reads as follows. And I believe we've submitted these. If we have not, we'll make sure you get these. But the mining education tax is imposed on a business entity engaged in the business of extracting and selling gold or silver or both within the state. And so we believe that that change is important to be there. Lastly, I would like to take a moment to address the collection period for the payment that will be due in April of 2020. It is our belief that AB 495 is clear on its face that the tax created by AB 495 is effective on July 1 of 2021. And as such, any attempts to collect revenue that are generated before its effective date would not be consistent with the plain language of the bill. And there's been lots of conversation around this. And if I may, the concept of a retroactivity tax just really invades the general sentiment of fairness. But from a rational perspective, there are really 3 areas as to why a collection for any conduct that happened before July 1 of 2021 should be disallowed. Number 1, there was no intent for this tax to apply retroactively on conduct that happened before this tax was passed. That's not clear. Again, this is a result of hundreds of hours of discussion. There was never any talks about that there. When you look at the bill itself, there is nothing that indicates that there should be retroactivity. I know that there's been conversations around whether or not Section 62 would have that level of application, but I think Section 61 that particularly uses the term retroactivity is quite persuasive that if there was intent for there to be retroactivity, that would have just been included in Section 62. Further, section 63, where July 1 is actually listed, if there were an intent for there to be retroactivity, again, the sections 1 through 44 that actually impose these tax would have actually been moved to a different section and stated that. And furthermore, when we look at the record that has the presentation of the tax, never was there any conversation around the concept and the idea of retroactivity. And that is something that, I mean, again, I believe is very persuasive, because again, if there were conversation, something as major as retroactivity is something that you would discuss in a hearing if that were indeed the intent. The second area that I would talk about is just kind of if there is some sentiment that there is some level of ambiguity that is created within the bill. I do believe that NRS 360.291, which encapsulates the Taxpayer Bill of Rights, would require that construction be made in the favor of the taxpayer. Again, that is, clear that the Taxpayer Bill of Rights provides protection so that a taxpayer is not caught off guard, a taxpayer is not unfairly prejudiced where there may be ambiguity that exists within a regulation or even within a taxing statute. And last, I would just say the retroactivity application really violates, of a new tax, violates constitutional principles of due process. It is quite clear within case law, and again, I'm not here as an attorney, I'm here as the president of the association, but it's quite clear that whenever you have a new tax, the concept of retroactivity has been disfavored by the federal Supreme Court and been disfavored by even the state's Supreme Court. And the reason for that, again, is you are imposing an obligation on past conduct. And again, that just flies in the face of fairness and due process, which key component of that is notice that the conduct that you take, there will be some level of obligation that is attached to that conduct. And so for those reasons, again, we would suggest that this commission undertake amendment. And again, that amendment would fall into page 14, section 17.1. And again, that rewrite would read as follows: the mining education tax is imposed on a business entity engaged in the business of extracting and selling gold or silver or both in this state occurring on or after July 1 of 2021. I believe that those the amendments that we suggest are complete enough, and they are within the ambers of the duty and the authority that this commission has today. But I will pause because I've been talking a lot and you guys may have some questions for me.
Hey, thank you, Mr. Gray. Is there any questions of Mr. Gray or Director Hughes?
I do have a question for Mr. Gray. I just want to clarify that you were involved in the process with the legislature start to finish. That's correct? I mean, we're counting on your discussion of the intent of this new tax. And from my understanding, you were part and parcel of this discussion the entire time. Is that right?
Yes, Commissioner Byram, Tyree Gray for the record. You are correct. Every meeting of consequence that happened during the legislative session and even some before the legislative session, I was an active participant in those meetings, both those that happened in Zoom and those that happened in person. So there was not a single meeting of consequence that occurred around the creation of this tax, which would eventually become AB 495, that I was not involved in.
And so with the effective date anticipated to being the date that it was passed, or July 1 effective date, was there any discussion around the budget or the budgeted proceeds that were to come from the tax being in the fiscal year that started July 1 of 2021? Or was there discussion with there to be a 6 months worth of revenue in the previous year? What was the discussion around the revenue that was going to be generated for the taxable year or for the year ended December 31st, 2021?
Thank you, Commissioner Byram, Tyree Gray again for the record. The discussion around revenue that was going to be generated by this tax was kind of a three-pronged record. Number one, you have the fact that the mining industry is currently still under the prepayment obligations. And so during the prepayment obligations, the price of minerals were estimated at a particular price. I believe the number that was estimated was about $1,700 an ounce. As we all know, the price of the minerals that are subject to this tax, particularly gold, has been performing far above that. And so the intent was that there would be credit that would be established based upon the fact that we would be providing a corrective payment, if you will. And again, for those of you who don't understand how the net proceeds of minerals works, it is a calendar year tax at the end of the calendar year. It is truly a property tax. The way that the property tax is calculated is how much do you sell the property for versus how much it costs you to extract it. Your costs of doing business and different things like that are not within that calculus at all. It is truly the price you sold it for minus the cost that it took you to extract. And so with the when we talked about numbers, really what we were talking about is being able to get to a target number. But I think a targeted number of that did not include the second piece that we did within AB 495, which is dedicating the the net proceeds of minerals tax to education. And so that target number was always estimated, and I don't have the exact estimate in front of me, so I do apologize, but it was always estimated with the credit toward receiving overpayment or corrective payments. But what's really important about that is that during the conversations that we're having around AB 495, AB 495 was intended to be a fiscal year tax and not a calendar year tax. And so the concept of AB 495 becoming a calendar tax versus a fiscal year tax is really why we have this weird situation of whether or not there's a 6-month period that should apply retroactive versus knowing that July 1, the tax was to begin to accrue. And so that's really where we have, I mean, if I'm to be frank, that's really why we have this hiccup today, which is the concept really is because it was supposed to be fiscal versus calendar, and it was drafted as a calendar year tax. So I know that it doesn't necessarily answer your question directly, but it does kind of hopefully frame why I think we sit here today.
Yeah, that does help. Thank you.
Oh, excuse me, Commissioner Byron, are you finished?
Yes.
I didn't mean to interrupt you. This is Commissioner Bursey. I have a question regarding section 14 of the draft language. Section 14 addresses when goods or services are provided on a complementary basis for the purposes of the exclusion from gross revenue of a business entity. And I guess this question goes to Director Hughes. Can you, for my edification, can you give me an example of a circumstance where this exclusion would apply in the mining industry?
Thank you, Commissioner Bursey, for the question. I cannot give you an exact example of where this would occur. However, because this is listed in the bill under section 10, subsection 3C of AB 495, we thought we needed to have some clarifying language in the regulation to describe that what occurs in a complementary situation. And I can't think of any instance offhand, but that doesn't mean it won't occur. So we were just making sure that we did have some language in the regulation to address this.
So the language was thrown into the bill in the event that the situation might occur.
I can't address that because I wasn't part of the drafting of the language for the bill, but I'm sure that could be said
Commissioner Byram, do you have any comment on that?
Yeah, I think that, and I know the language was probably written towards the end of the session and some of it may have been rushed, but I believe that some of the language in the bill might have been borrowed from commerce tax. And that provision appears to be if you were to own, or if you had a membership at a casino and you were receiving coupons, complimentary meals or whatever, it looks like it was meant to capture an individual patron at a casino rather than anything to do with mining. But it is nevertheless a provision in the bill. I don't think it should be expounded upon in the regulation because I think it invites shenanigans. Because you've just given an idea to a taxpayer, here's how you can exclude revenue from your total. Not that it makes any sense or would ever be done, but it's there and it's part of the bill that they then discussed further. I don't see any reason for it. But then again, if you were to look at canons of statutory construction, there's an assumption that the language wasn't there to be meaningless. It has to have some meaning, which is a problem, I think, just in the way the bill is written. Not necessarily the regulation. I think the attempt in the regulation was to clarify.
Does staff feel strongly about leaving that section in? This is directed to staff, to Director Hughes.
I would have to speak with our tax manager, but this also was language that was provided by the Nevada Mining Association that we just kept in the regulation. So if industry is in agreement as well, we could look to remove that if necessary.
Well, I don't want to hold up approval of this regulation, so I'll just leave it at it. It was just a question that I had.
Mr. Chairman, I'm not sure if you are ready, but I would like to make a motion.
Could we hold off on that for a second? I think there's more discussion, if you don't mind, please. So my question, Mr. Gray, I understand you're wanting to amend section, let me find it. I believe it was 17, but section 11 is really the section where it details when that accounting period for that tax is delineated. Could I don't know if it's Director Hughes or the Attorney General's office, what's the impact of changing that date from July 1st to, or from January 1st to July 1st? What's the impact to the state or stakeholders or the folks that are supposedly the recipients of this, those dollars?
This is Director Hughes. I'll attempt to answer this, and if David Pope would like to clarify, he can do so as well. Section 11, this language was drafted and approved by LCB as the applicable period, and it's provided in the plain language of the AB 495 under Section 62 and read in conjunction with Section 17. So I can't give you the fiscal impact that would occur, but LCB intended for this language to be in the regulation.
Okay, well, maybe the question is so if it's in the bill in section 62, Mr. Gray, did you see that in section 62 all along before it was voted on?
Yeah, so just as a clarifying point here briefly, as you look at section 11, we actually did have a proposed rewrite to section 11, and I will read it briefly as follows. The mining education tax means the tax imposed by sections 2 through 40 inclusively, excuse me, of Assembly Bill number 495. Excuse me, my apologies, I was reading the wrong, my apologies, please. Please strike everything I said there. Our proposed rewrite to section 11 begins page 11, section 11, and rewrite section is as follows. For the purposes of the mining education tax, the taxable year is a calendar year, comma, the 12-month period beginning January 1 and ending on December 31st, period. The concept and the idea of Section 62 was always to be able to provide additional revenue for the state, or I should say to get revenue into the state earlier than later. Again, I think it's important to kind of harken back to where we were in May of 2021. In May of 2021, we had an idea that there would be federal funds that would be coming to help to bail out the state. It was unclear when those funds would arrive and when those funds would eventually be provided. And so even when we look at the first legislative special session that happened in the summer of 2020, that is why the state requested from the mining industry to prepay its taxes. Because again, everything was about being able to get revenue in order to be able to sustain our education and those other programs that we need dollars to fund. Now, if we fast forward a little bit in May, we get to the point where we understand that the state will be receiving somewhere in the area, when you aggregate it all out, I think you mean about $8 billion. And so the need for immediate revenue, again, by virtue of the federal government passing ARP funds and the other funds that have been allocated through the federal government, the need for immediate revenue basically kind of went away. However, the language of the bill with Section 62 was meant to allow for the tax to be collected in 2021. So therefore, for an obligation to accrue in 2021, but not to act retroactive against conduct that has already happened. And so whenever you have if you have like your property tax, for example, if your property tax and you pay it on a calendar year, if it were to change in the month of October, that doesn't mean that you'd have to go back and pay for January through September. That would mean that the obligation would begin to accrue in October of that time. And so the effective date has to mean something, just like the argument maybe Section 62 means something. Well, Section 62 just means that in the calendar year, because of Section 17 that creates this tax as a calendar year instead of a fiscal year, we want to be able to collect revenue. And so in order to collect revenue, we must make it apply to the calendar year. And even though the calendar year begins on January 1, the effective date by which the obligation begins to accrue is July 1 of 2021. And I'll pause there just in case there are any questions.
Any questions or comments? Okay, very good.
Commissioner Byram, just a quick comment is that does line up then with how the state will tax for net proceeds purposes a prepayment scheme, which they've put in place and then unwound a number of times to help fulfill the needs of the budget. And it went back into place. And so now it comes together and it makes sense why the language was written the way it was. And I appreciate you adding that, Mr. Gray.
Commissioner Lippman, I wonder if David Pope wanted to weigh in on the budget issue.
Thank you, Chairman, Commissioners, Commissioner Lippman. I don't have information about the effect on the budget, but my comment would be that Section 11 in the reg is just a combination of the plain language of Section 17 and Section 62. And the plain language is where we start, and then we live with the plain language of the bill. So that's my comment. Thank you.
Thank you. Any other comments or questions?
Chairman DeVold, would I be able just to address one of Tyree's comments?
Yes, please. I apologize. Yes.
That's okay. I wanted the commission to know that our initial language that we submitted to LCB did include provisions to name the tax the gold and silver education tax. LCB did not approve that language. But the department will work with the Nevada Mining Association and our legal counsel to see what we can do within our authority to reference this tax as an education tax. But since LCB did not approve the regulation language referencing the tax as such, we cannot formally call it the education tax.
I think the taxpayer would appreciate some kind of reference to supporting education. I think that's their whole goal here. So anything we can do on that front, I think that would be beneficial.
So, Mr. Chairman, as a clarification from what Ms. Hughes said, does that mean we can't make amendments to this as we have it today? I think that we can. Ms. Hughes?
I'd like David Pope to weigh in on this, but it's my understanding if you do make these amendments, I'm not sure LCB will find that we have the authority to make certain amendments.
Okay, Mr. Chairman, if I could ask Ms. Bordelove the question then.
So LCB's already sent, Ms. Rosalie Bordelove for the record here, I apologize for that. LCB has sent the language that they've approved so far. So if you were to make substantive changes at this point, it may need to go back through some of that process. For example, the naming, you may have some issues when it gets to legislative commission. So I guess I'd qualify with that. Although to the extent that you're not making largely substantive changes right now, I would definitely say go through that process, and you definitely can make some of those changes. I just wanted to qualify if you were to make substantive, you may have to go through a few more steps again.
Okay, thank you. That's my understanding also. Thank you.
Thank you. Commissioner Byram, did you have a motion? I think we're ready for a motion if you're
Chairman DeVold, we need to have public comment.
I'm sorry. Thank you so much. I appreciate
Thank
that.
you.
Yeah, thank you for keeping me in line. I appreciate that immensely.
If anybody has public comment, please dial *9 if you're on the telephone or raise your hand in Zoom. Jay Velardita.
Yes, thank you, members of the commission. My name is John Velardita. I'm the executive director of the Clark County Education Association. We represent over 18,000 educators here in Clark County, and we actually educate over 72% of all students in the state of Nevada. I was a primary participant in the AB 495 being passed. We worked very closely with the mining industry, the legislative leadership, the governor, and other stakeholders. I'm here to speak to support naming this tax the mining education tax. And the reason is very clear, is what the intent was behind passing this legislation. Another piece of legislation that was passed in that last session was SB 543. It reformed the funding formula for K through 12 education. And within it, it had specified funding streams that would go directly to K through 12. It was in that context that AB 495 identified the new tax on mining to go specifically through K through 12 public education starting in the fiscal year 2024. So intent is meaningful, and in politics, it's very important to kind of memorialize that, because we do have term limits, and there is different legislators that get into session, and we'd like to support having this tax named what the intent was, and that's the mining education tax. Thank you for your time.
Thank you, Mr. Velardita. Any other public comment?
Yes. Phone number ending in 130. Please state your name and spell it for the record.
Good afternoon, chairs and members of the commission. My name is Christine Saunders, and I'm a policy director with Progressive Leadership Alliance in Nevada. Assembly Bill 495 from this past session is a strong start to addressing the privileged position mining is held in Nevada's tax code and now. We believe that the regulations that were put out by the commission properly implement the intention of the legislation. While we have heard some concerns about the name, we believe the name of the tax should remain as the gold and silver excise tax, which is in line with the naming convention of other taxes being based on what is taxed, not where the revenue goes. In addition, we support maintaining the taxable period for 2021 beginning on January 1 and ending on December 31. This seems abundantly clear in Assembly Bill 495, Section 62. While this bill was introduced towards the end of session, conversations were going on behind the scenes for months prior, and 2 amendments were made before the bill was signed. We need to preserve what was voted on with bipartisan support and full view of the public rather than manipulate it during the regulatory process. Thank you.
Thank you, Ms. Sanders. Any other public comment?
I do not see any other public comment at this time.
Okay. Is there any other discussion from the commissioners?
Commissioner Lippman, Executive Director Hughes, just the second edit that Mr. Gray proposed, which is to make it very clear that it's not just about extracting, but it's also about extracting and selling. That's clarifying language that I know Commissioner Byram suggested and that looks like has been integrated throughout. So that second, so is that consistent with the spirit of the other language? It seems to me as that it is, if that is not, that's substantive and again is more clarifying. Would you agree with that?
I was looking at Section 4 of AB 495, which defines what is a business entity. And I think that may address the type of business that Mr. Gray brought up in his discussion. So I'm not sure if it needs to be further defined in the regulation or if that section is enough. So I hope that answers your question.
So it's clarifying and is not changing the substantive nature of the provision at all. But what you're saying, it maybe doesn't have to be clarifying, but it certainly does continue to clarify.
Correct.
Thank you.
Thank you, Commissioner Lippman. Any other comments? Commissioner Byram, I believe you had a motion you wanted to make.
Yes, I would move to approve the adoption of a permanent regulation LCB file number R130-21 with language that was received as of this morning with the edits as of this morning, but modified by the 3 edits that have been suggested by Mr. Tyree Gray, including the name of the tax being mining education tax, the clarification about the contracted service so that it was both extraction and selling, and also to clarify that the effective date for any taxation is July 1 of 2021 going forward.
Commissioner Wren, second.
Yeah, I've got a motion and second on the floor. Is there any other discussion? All those in favor, please signify by saying aye.
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 Aye. Anyone opposed? Motion passes. Thank you, everyone. Director Hughes, the next item on the agenda is informational items. Director Hughes, you're on mute. I apologize.
Sorry about that. 6A is penalty and interest waivers granted by the department for sales use tax, modified business tax, and excise tax. And item 6B, approval and denial status report log for organizations created for religious, charitable, or educational purposes. And we provided this information in your packets for your review.
Are there any questions on the informational items? That doesn't require a vote, but okay. I don't see any comments. Your briefing, Executive Director briefing.
Thank you. Today, I only have 2 items to bring to the Commission's attention. First, we have had a few changes on our executive team. Melissa Flatley joined the department as our new Chief Deputy on January 10th, and Jennifer Roebuck was promoted to Deputy Director of Compliance on January 3rd. We are excited to have both of them join the executive team. And I also wanted to recognize Guy Childers. He has been promoted to Audit Tax Manager. That was left vacant from Jennifer's promotion, and Guy starts his new role today. And the second thing I wanted to brief you all on is the MBT refunds. Since the first round of refunds had been sent out in August 2021, the department has been diligently working to make sure the remaining refunds were sent out in a timely manner. And at the beginning of this process, we estimated that $80.3 million would be refunded, and that included interest. As of today, the total refunded amount is approximately $64.9 million. The remaining balance of approximately $15.4 million has not been refunded to taxpayers due to out-of-date account information and/or lack of response from the taxpayers, and it has been placed as a credit on a taxpayer's account. Once the taxpayer updates its account, a refund can be issued, or the taxpayer can choose to use the credit on a future liability. In some instances, if an account had an existing tax liability, the credit was applied to that liability pursuant to Nevada law. We are still asking taxpayers who believe they are due a refund but have not received it to contact the department. And this concludes my briefing today.
Thank you, Director Hughes. Any questions of Director Hughes at this time? See none. Thank you very much. Our next meeting is March 7th, 2022. At this time, is there any public comment, Tina?
If you would like to provide public comment, please dial *9 or raise your hand in Zoom. I do not see any public comment at this time.
Okay, very good. Are there any items for future agendas from any of the commissioners? Not seeing any, we'll stand adjourned. Thank you all for your time today. I appreciate it. Take care.
Thank you.
Thanks, everyone. Have a good day.
Thank you.
Thank you.